Yeah, right. Okay, so we're going to start off with the amendment that we had on Delegate Vandari's bill and Senator Klossmeyer's bill. I'm going to bring that up. I think folks have got some greater clarity on what the amendment does. So if we could just reintroduce that again. I think what we'll do is we'll attach it, if everyone's amenable, we'll attach it to the House bill, kick that out, and then I guess I can add that. I can.
You'll withdraw the amendments that were previously voted out, and these will replace them.
Got it. So then I can. Okay. So we'll do that on the floor.
So this would add, as we were discussing before, add the option of the non-public educational program is provided under 8406 of the education article. If the registrant has notified the agent, or excuse me, notified an agent or employee of the non-public educational program that the registrant is required to register, and the registrant has been given specific written permission by an agent or employee of the non-public education program to attend the non-public education program. It also made a couple of clarifying changes in the lead-in language, and that's it.
Thank you, Mr. Chair. So to respond to Senator Cassidy's concern earlier, the second half of that is critical. The program in question has to consent to the individual who's on the list to be a part of the program. So it's not, they're not forced to take anybody they don't want to take.
Senator Hellerman shared me the letter that she was quoting from, and given when I was able to read through it, I agree with her interpretation. So I'm comfortable with the amendments.
I said last time they had to be admitted, All right. So, Senator Carter.
The question, I was a little late at the earlier session and I missed a lot of the discussion. So I understand the initial bill would have removed these students from the regular classroom, and the amendment appears to lay out the types of programs that the students are now eligible to be admitted to. Is that correct? And these are already established programs. And do some of these programs have, what are the other students that are already in these kinds of programs? Are they students with disabilities? Because I see it says, or, maybe injured home and hospital teaching.
For home and hospital, there are specific criteria for when that would come into play. I think the fiscal note has a pretty good rundown of, let me just pull that up, of the regional institutes for children and adolescents.
So we can cut to the chase. So the concern is we're removing them from other students because we've now otherized them because they have an offense and they're registered. The question and concern is, who are we putting them with now?
Senator
It's already been addressed?
So, yes, so there's a group called MANSEF, which is the Maryland Association of Non-Public Special Education Facilities, and they have about 70 different schools throughout the state, and they are special education schools, and they mostly have children who have IEPs, and they have a whole variety of different children with disabilities that they serve, but they also do make it clear in a letter they sent about this specific bill that they serve kids who are on the sexual offender registry, and they have specialized services for them. So they have the expertise, and they have been doing this, and so they wanted clarity, hence.
And without this amendment, what are the options for these students?
Well, so then they felt like they would not be covered without the amendment.
So they might not have any education at all?
Well, the ones that were already included under the legislation.
I got you. I mean,
the virtual and the...
There's something that I just find a little morally upsetting about it, but I will, I mean, it is what it is. I mean, so it's like saying, well, they can't be around the students that have no disabilities or any other issues, but they can be around other students that do.
Well, I
that
think
are in
that,
special, so now we're talking about, like, in some cases, the most vulnerable students, right? And we're putting the sexual registrants possibly in the same programs as them. Is that correct?
well, but I want to read a really important statement in which she says, some of our programs have established trauma-informed approaches specifically for students who have sex trafficking in their histories. So I hear what you're saying, but it's also, they have developed a particular expertise in being able to address the needs of these students.
Okay.
All right, is everyone okay with adopting the amendment to the House bill? Okay, great. All right, so now the House bill is the same as it's the same posture except for this amendment as Senator Klausmeyer's bill. So, what's the number? House bill?
40.
I just have the Senate bill.
48.
House Bill 48. So is everyone okay with the favorable on House Bill 48 as amended? Okay, it passes unanimously as amended, House Bill 48. Okay. Okay, now we're going to do some House bills. It's consent calendar that passed out of JPR unanimously, right?
Yeah.
Do we have that before?
Yes.
Can we
So-
pass that out?
They have, the list was emailed out yesterday.
This is 25 and 26.
Should be voting list number 26.
26?
25.
Yeah, there's a 25 and a 26. 26 is the consent calendar. So these are all bills that passed the Senate floor unanimously, and the House version is in the same posture as the Senate version.
Move to adopt.
Second.
Pass. Whatever the operative verb is.
Second.
All right, there's been a motion for favorable. It's been seconded. These are all bills that have passed unanimously out of JPR. This is the cross file. Everyone's okay?
So can I ask a couple of questions?
Sure, go ahead.
Okay. So,
Yeah,
on-
it's voting list 26.
Yeah. So for House Bill 128, Senator Castley, you voted no on the Senate version. Do you want to vote?
You're on this 25 now?
No, still 26, sorry.
Hold on, let me make sure. Yeah, voting list 26 starts with House Bill 115.
Right.
So House Bill 128, which is criminal law, hate crimes, protected groups, and penalties, you had voted no on the Senate version. Do you want to vote no on the House version?
So they're not unanimous then, right?
No, they were unanimous on the floor.
Oh, on the floor? Okay,
Right.
then no, I'm fine.
Okay.
I'm fine.
Wait, hold on. I want to make sure we get this right. I thought this was unanimous in the committee and the floor, so is it, do you want to just keep everyone's votes the same as they were in committee and floor?
There's only 3, so
Okay,
I
got
can
it.
ask if you just want me to go through real quick. So Senator Castley, you're a yes then on 128?
Yeah, I was yes on the floor, right?
You didn't vote on the floor.
You can give me a no in committee, and then I'll just, so I don't hold the committee up, and I'll look at it and see what I'm doing on the
Okay.
floor, okay?
And then Senator Carter, House Bill 277, you were a no on the Senate version. It's criminal law, first degree, child abuse, continuing course of conduct. Do you want to be a no on the committee for House Bill 277?
Can I vote yes on the floor? You did. Okay, so I was just making a point in committee. This is the one where I thought we were changing the character of the crime, correct? I think so.
These were 3 or more instances.
I don't care. I've been outnumbered. I think it's poor policy, but I'll go ahead with the committee. I'll take one for the team.
Okay. And then Senator Heddleman, on House Bill 730, you voted no on the Senate version. This is the administration's bill, driver's license.
Yeah,
Huh?
it's fine.
Okay, got it. Okay. Thank you. Thank you. Voting list 25 is a list of bills that where the cross file passed, but they were either not unanimous on the Senate floor or they're not in the same posture as the Senate version. So we can start with House Bill 89. Josh?
Yeah, this bill is the cross-file to Senate Bill 397. The bill authorizes diminution credits to reduce the term of confinement of an individual who obtains certain educational certificates or degrees. The deduction allowed to be 60 days per program completed, or 40 days for an inmate serving a sentence for a crime of violence. Although an inmate serving a sentence for murder in the first degree or a sexual offense requiring registration would not be entitled to the credits. So the two substantive differences between this bill and the bill that was passed out of this committee are that this bill restricts an individual to getting DIM credits for no more than one technical or vocation training program, or no more than one associate degree, or one bachelor's degree. And in addition, the Senate bill only excluded individuals who are serving a sentence for a sexual offense requiring registration. The House bill additionally excludes inmates serving a sentence for first-degree murder.
Probably like the House version. I mean, I would ask that we would, that we would amend the House version to match the Senate version that we passed out.
I'd prefer not to take the argument of defending first-degree murderers getting it, so I would prefer to stick to the House version.
I figured that. But here's the thing, that no other pieces of legislation that we've passed this year change the fact that people are going to be released from prison, that the average person serving sentences in our prisons, the average educational level is between 5th and 8th grade education, that it is in everybody's interest, in society's interest, that they come out of prison with education and abilities to be employed. And so all this does is give them the credit, the bonus credit for the completion of a program. And keep in mind, they're getting credit for being in a program. We're just giving them the bonus. So for those reasons, I get that, we're very upset about some of the other legislation that passed that encompasses people that are convicted of murder, but we didn't make that restriction when we passed this bill 3 times out of this committee. So, I mean, it's the committee's will. If that's what you want to do, I think it's important to get a bill done, because the policy and the principle behind this bill is very, very, it's a great one. It's one of my favorite bills, actually, because we're actually rewarding accomplishment and helping people prepare for reentry, as opposed to just doing things that allow people to get, the credits that aren't necessarily earned. This is a better bill than some of the other bills that we've passed.
I just, adopting what Senator Carter said about the average educational level of an inmate. Well, this bill, the House version, says we'll award you for getting your high school diploma, so that's a huge step up there. And then you'll get an associate's degree, but not more than one. You only need one associate's degree. And then you can go and get a bachelor's degree. And the only real limitation here is that you can only get one bachelor's degree. I mean, look, quite frankly, who the heck gets more than one bachelor's degree? Other than if you were for some bizarre purpose. So I think the House bill is a pretty good, I think what they've done, I mean, I agree with everything we're trying to do here with encouraging education, but you're moving people from elementary school educations up to bachelor's degree. That's a big climb. So I think it's a good bill.
Senator Carter, anything else you want to say?
The committee's will, but I think the product that we passed was a good one. So I want to be clear. The only difference, Council, is that they took away the credit for people convicted of murder, or I'm not sure if I'm clear what the distinction is.
Yeah, so it's the Senate bill excluded registered sex offenders. The House bill additionally excluded first-degree murderers, and they limited the associate's degree and bachelor's degrees to just one for inmate.
Okay.
To conform to the House?
Wait, so if you conform to the Senate version.
No, well, so they would adopt the House then.
You want to adopt the House.
Yeah.
So
That's
then
the
that would
motion.
be a favorable. Then you
So-
just motion favorable.
Okay.
So
You just roll it and see what happens, but.
we can do that, but so. Mr. Chair, do you have any knowledge about like how the House is treating this? I mean, are they going, if we conform to the House, are they going to pass the Senate bill?
I don't have any particular knowledge on it, but I will certainly inquire. I mean,
You want to hold it?
Not necessarily. I don't want to hold it. I mean,
we can't hold this with
this
my
bill
delegate.
has
We're gonna
been
hold
3
this.
years in the making. I just assume get the bill done, but you know, we are conceding something, even though there are some members of this committee that are in favor of that concession. I just want to make sure that we have
an amendment on it.
equal treatment.
Laid over on the floor.
You don't have to
Alright.
do that. It doesn't have to happen for a House bill, right?
So what?
To lay it over? What are you
It
trying?
has to have amendments to lay something over, but.
Is that true for a House bill? I think you can amend a House bill on third reader. You could lay it over.
Well, just Jill, if they don't move yours, we could. I could offer amendment and lay it over on third reading.
All right, so let's roll that. Unless anyone has any other objections.
So we're rolling up on the House bill.
Correct.
That's what we're saying. Okay.
Yes, so this is a favorable motion for House Bill 89. Vice Chair Waldstreicher,
Yes.
Senator Lee. Yes. Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
Bills passed favorable.
So this bill establishes standards relating to the installation and use of electronic vehicle recharging equipment in condos and HOAs. So JPR has two options here. Option one is to make the identical change that was adopted in the Senate version, which would mean strike the language that you did not like, the is not impossible, and replace it with is reasonably possible. It was noted that replacing is not impossible is technically a substantive change for is reasonably possible, because an individual could then evaluate, well, is it reasonably possible, whereas is not impossible is much more of a stricter standard. So you could instead just simply strike and is not impossible from the bill.
Amended the Senate version.
So this is on page 3 of the bill, if you're looking at the Senate bill, if you want to see what the amendment would look like.
You guys want to do?
Yeah.
I mean, you can't have something that's not impossible. My God, what a ridiculous standard that is.
Well, the alternative proposal was that the installation does not unreasonably impede the normal use of an area outside the owner's parking space, period. So that way you wouldn't even get into the possible, not impossible part of the bill.
Aren't there more factors than just impeding somebody else's? I thought we were looking at broader issues about just sort of reasonableness of doing it. And they're saying, well, you have to do it unless it would impede, which is like, okay, but that's our only reason for rejecting is that it would or wouldn't impede. But there may be other issues that say this is just not reasonably possible to do this.
Correct.
So I think the Senate version's a good reasonable approach to that. I don't know why we'd want to. Thank you.
So to conform to the Senate?
Yeah. And Senator Bailey.
I agree. I think, and I make the motion that we conform their bill to what we passed here in the Senate.
So this is the cross file for Senate Bill 293. There was a slight amendment to the Senate bill, which simply clarified that in order for the bill to apply, a pedestrian or an individual who is riding or leading an animal on a highway, shoulder, crosswalk, or sidewalk must be doing so lawfully. The House bill did not contain that amendment.
Thank you, Mr. Chair. So this is cross out of my bill. I move that we conform this to the Senate bill, please.
Heather, I think this is you, right?
For this bill, I recommend conforming to the Senate version because the House bill is missing a technical correction that was recommended by Department of Human Services. It simply needs to strike the language and foster youth in one location in the bill, as requested by DHS.
Everybody okay with that? All right. Charles, this is your crosswell, right? House Bill 289? Is that right?
Yeah, it's gonna go 105. Oh, sorry.
Yep.
Again, I recommend conforming the House bill to the Senate version. The House bill does not have the amendments that JPR adopted dealing with the amendment that specified that the bill may not be interpreted to create or impose a duty on an employer to file a petition on behalf of an employer. And it also is missing the JPR amendment that removes an immunity that the bill created for employers.
Yeah, I tried to get word, but I mean, the will of the committee, which is the Senate version, so.
Seconded. Is everyone okay with that? All right. Josh, 301.
This is the cross-file to Senate Bill 265. There were some substantive changes made to the House bill. The House bill clarified that on or after July 1st, 2022, an organ donor may designate their donation for research or education or transplantation/therapy purposes. It limited a donation with a general intent made on or before July 1st, 2022 to be for transplantation or therapy. It adds provisions requiring organ procurement organizations to provide the MVA with certain educational materials and requiring the MVA to display those materials, and it delayed the effective date of the bill to July 1st, 2022.
Thank you, Mr. Chairman. I'm in touch with the House sponsor as well as the advocacy groups behind the bill and the MVA. The amendments that were accepted in the House are good amendments, and so I would move the House bill clean, please.
Great. Is everyone okay with that? Excellent. All right, we've got Heather, you're up for the next three. House Bill 861.
So for House Bill 861, there are 2 points. So the first point is that it needs a technical amendment. It is missing the "and" on page 2, line 20 of the bill. So that was requested by editing. And then the other point with this bill is that it was not unanimous. So in JPR, the nays were Senators Castley, Bailey, and Huff, and then the floor vote was 33-12.
Make the technical correction, conform the House to the Senate bill.
So they don't need to conform, it's just the amendment itself was missing a technical correction.
Okay.
So just say, yeah, just adopt the "and," the technical correction. There was just an error in the amendment.
Your vote from the prior vote on the cross file, just record as the same. Okay. Senate Bill 885, or House Bill 885.
So for this vote, it was not unanimous in JPR. Senators Bailey and Senators Huff were nay. And then the House floor was 38-7. Sorry, the Senate vote on the floor was 38-7. Otherwise, the bills are identical.
Okay, recording the same vote. All right. House Bill 1023.
For House Bill 1023, the proposed amendment JPR needs to consider is the effective date of the bill. So as passed by the Senate, the effective date was the standard effective date of October 1. The House passed the bill with the effective date of June 1. Otherwise, they are identical.
What was the House, did they adopt an amendment to extend the effective date?
The House made it an earlier effective date because the proponents of the bill, they had wanted it to be an emergency bill. The House did not do that,
Yes.
so they made it a June 1.
You have HOA meetings virtually. I think it's fine to have it in June. They're probably doing it now.
So, okay, go ahead, Senator Sidor.
Just a quick question. This is something that I had raised earlier on. Do we know if all of these companies now that are business organizations and in the state of Maryland can do this?
No, I don't know. Remember we said we were going to do like a broader kind of study on that, but this, I don't know.
Can't you get a Zoom account?
Fair enough.
I mean,
Fair enough.
I mean, I think it's a good idea. I mean, obviously, like you said, they're doing it now.
yeah.
But I just wasn't certain if there was someone that was left out that technically cannot do this, so, thank you.
We adopt the House amendment. It doesn't adopt the House amendment.
Okay, so
Yeah.
that's it.
Is everyone okay with that? The earlier effective date? All right. I guess we got one more, right?
Yeah, we need to hold 1061, right? Because we don't have a letter from the
We
Senate
don't.
delegation for the House version.
Did we pass the Senate version? Go ahead.
Oh wait, sorry, Heather, go ahead.
So for House Bill 1061, the House expanded the scope of this bill to include dwelling units. This was not considered in JPR, and I have not received an updated delegation letter. And based on the House version, there was new opposition that was submitted to JPR for the House version that was opposed. That was not in opposition for the prior version of the bill. So for that, I would recommend holding until a delegation letter at least.
All right, Senator Jackson, go ahead.
Holding is fine, thank you.
You. Okay. Held. All right, Josh, Senate Bill 1261.
So this is the cross-file to Senate Bill 820. So both of these bills were amended, however, the amendments were not exactly identical. So there are a number of non-substantive kind of drafting differences, which I understand the House is planning to conform the Senate bill on those matters to the House bill. But there are two substantive differences between the bills. And the first is that in this committee, the amendments added a new requirement when a will is electronically executed that the supervising attorney provide an acknowledgement, essentially stating that the testator is free of undue influence. And the other substantive difference between the bills comes at the very end of the bill in the uncodified language, which governs the application of the bill. There were some changes to that language made to the Senate bill, and it seems that those were a drafting error. So I'll let the bill sponsor explain in greater detail, but well, I think I'll let the bill sponsor explain what his preference is.
Thank you, Mr. Chair. So the drafting area needs to be checked or corrected. As originally drafted, the bill provided that it took effect as of last March, thereby validating everything signed in the meantime. As somehow an amendment slipped through us that changed that to, it goes into effect this coming October, which would leave all those previously executed documents in limbo. So we need to restore the March 2020 effective date of the bill, or retroactivity date of the bill. The amendment was the one that we enacted in response to Senator Cassidy and Senator Huff's concern about undue influence. So that amendment should remain in the Senate bill and should be added to the House bill.
Conform the House bill to the Senate bill, but then add an additional amendment. Is that what you're saying? Yeah, that's what Josh. Sorry. Yeah.
So unless I'm mistaken, so it wouldn't be exactly conforming because there are a number of kind of non-substantive differences that I understand the House will conform on those points. The House will conform what the Senate bill to the House bill. So
The same position.
except that we are adding the acknowledgement that we added to the Senate bill now to the House bill.
Yes.
So that would be the only amendment to the House bill that we have before us.
Yes, that's right. And we should recommend to the House that they change the retroactivity date and that they make the conforming technical changes.
The House bill to the Senate, what we did in the Senate, and then add this additional amendment to the House bill. Am I missing something?
I think we need to change both bills. It sounds
Well, they have to do that, though. We don't have the Senate bill.
They have our bill in their
Yeah.
hands, so they need to make the technical changes over there.
Yeah.
And they need to change they need to add that amendment there. And we need to change the date of retroactivity here to reflect the correct date, which the House bill, excuse me, it's getting
Which
confusing.
we had, they don't have.
No, so I believe that the uncodified language at the end, which is a retroactivity application provision, that is correct in the House bill that we have before us. The Senate bill is, right, the Senate bill is, that's where it's incorrect. That is currently in the House. So the House would change that, and they would make the non-substantive changes, and we would simply be adding the acknowledgement form that we added in the amendments over here. So that would be the only change to the House bill.
The acknowledgement provision to the House bill, right?
Correct.
Okay, that's my motion.
Okay. So now it's before you guys amended. We just passed. Everyone's fine. Okay. Was that the last one on?
Yep, that's it.
Do we have any other list? We're good to go.
Do you want to go back to it?
Thanks. So we'll go back to House Bill 670, and this time we're just going to we'll go systematically through the bill with the new language. So we'll start, Jamie, just walk us through, and we'll address questions, have debate. We'll just march through the bill.
All right, so if you want us just, as he's going through, if you want us to propose changes, do you want us just to stop Jamie, hit our lights? What do you want us to do here?
Yeah, just hit your lights. We'll call on you. We'll
Okay.
start the debate.
All right.
So turning to the reprint, the amendment strikes the language right up to page 14. So that's where we'll start. And that's page 14 of the reprint. This is new language. It's section 2109. And this pertains to traffic stops and requirements during those. It provides that at the commencement of a traffic stop or other stop, so actually further than traffic stops, absent exigent circumstances, a police officer shall, display proper identification to the stopped individual and provide the following information to the stopped individual. The officer's name, the officer's badge number, the name of the law enforcement agency the police officer represents, and the reason for the traffic stop or other stop. Subsection B of that section provides...
Did you have something you wanted to get?
I just don't think there's any opposition to this particular provision. We can probably move through it fairly quickly. And I also don't think there's going to probably be any opposition to the next sections dealing with loans and scholarships.
So just real quick, I know we want to move quick, but this comes from a bill from Senator Sidor, whose name won't be on this, obviously. So I just want to thank him for putting this in because it's getting included and worked in, and he worked really hard on this section.
Curious maybe for the police officers on the committee that could, I mean, I know it just seems a bit much. The officer comes out, they say their name. The officer's going to have to read off their badge number too? Is that what we're saying? Or they have their badge on? I mean, so they walk up, hi, I'm just curious how the police officers, how this works. I'm trying to think. I mean, unfortunately, I don't get pulled over speeding that much, so, because I drive within the speed limit all the time.
You are a better
I do
man
not
than
have
I am.
senator tags.
All right.
I have never had those. I can say that.
Well, Senator Jackson or Bailey, you want to, Senator Jackson, go ahead.
I guess my concern is, I mean, is this reasonable? I mean, usually they come up, hi, I'm officer so-and-so, and they actually don't say, they say, do you know why I pulled you over?
Look, I think the only thing that I don't think I've ever done was say my badge number. You say your name, you say, Corporal Jackson, Prince George's County Officer, the Sheriff, I'm pulling you over because you, da-da-da-da-da. Badge number, never. I mean...
I just want to say, I've been pulled over many a time, unfortunately, in my life, and I have never, ever one time had any officer tell me who he was or what his badge number is. He says, license and registration. That is what I get. Okay? That is all that I get. What is your license and registration?
Seeing lots of affirmative responses on that one. All right, Senator Bailey.
So, I mean, clearly, a lot of people have been watching a lot of TV shows. But I want to bring this back to reality just a little bit. Fact is, every time a person gets promoted in a police department, their badge number changes, right? Badges they go by rank. So putting their badge number on there is a little bit ridiculous, right? That should not be on there. And the other thing, if we go down to Roman numeral 4, the reason for the traffic stop or other stop. I mean, quite frankly, if you have pulled over somebody that is suspected of being under the influence of alcohol or under the influence of drugs, right, they're weaving in the lanes, you want to ascertain from them in your first questions if they understand why they were pulled over, if they were weaving, if they were speeding, right? The fact is, when you pull somebody over and you go, oh, the reason that I pulled you over is you're weaving all throughout the lanes here. You almost caused an accident, right? That doesn't make sense. You want to gather from them if they're familiar, right? Clearly they know once you've identified yourself, right? When you pull a car over, you walk up there to the car. If you're in uniform, you clearly have a uniform presence that you've identified, and you identify yourself with your name. Now, depending on the situation, how the situation is, whether the car is full of a bunch of people or there was one occupant, things could be go differently based on officer safety when you walk up there, right? If you walk up there and things. You have a lot of furtive movements, and you've got exigent circumstances, things might progress pretty quickly, to say the least. So the situation is, I think that the officer's badge number clearly is not appropriate. I think during the stop, it is important that they learn what it is. But when it says, provide the following information to the stopped individual, well, the officer's name, you're going to clearly do that when you walk up to the car. And most of the time when you stop somebody for an offense, they're more likely going to get a piece of paper that has your name on the bottom of it, so they'll be able to remember who you were. Now, on that, normally when you put your number on there, on the citation, I'm not familiar with any citation that lists a badge number. What each officer has that is a clearly identifying number to them is their district court identifier. That number clearly is a number that identifies them to the District Court of Maryland and is a number that sticks with them no matter how they go through the rank. So I do think that we should clearly strike the officer's badge number.
I'll second that because I just found state troopers do not have badge numbers. So you can't require state troopers to do this because they don't have it.
Well, if they don't have a badge number, that's going to take care of itself.
So we got a motion that's been seconded, but it's open for debate.
It's required.
Let's go ahead and Senator Jackson, and then did someone else? I saw some hands over here. Senator Castley and then West.
Look, Mr. Chairman, I thought we already addressed this at a previous hearing where we talked about ID numbers versus badge numbers. You know, nobody has a badge number in that regard. I thought we already addressed that. Well, but everybody has an ID number, though. You have a certification, you have an ID number. So when you get that ticket from that trooper, there's a number on there, brother, trust me.
It's not a badge number.
No.
I mean,
No, there's no badge. I thought we already addressed badge number. It's not a badge number, it's like an ID number.
so then you're saying that every law enforcement officer has a law enforcement identification number,
Yeah, but
regardless of
look,
agency or?
I think if I mean, I'm not even sure that 2 is necessary. I mean, the officer is identifying, so you must identify yourself as an officer and the agency that you're working with, and then you go into it. Because I think, again, we've been getting a little too prescriptive. It's like, I'm Corporal Jackson with the Office of the Sheriff of Prince George's County. I'm stopping you for this reason. Bam, you got it. That's the information you need. Do I say I'm ID 112 or I'm ID 380 or I'm ID number 1? I mean, I've identified who I am. I'm in uniform. I think, but I don't want to spend all day on an ID number.
No, I hear you.
Asking the officer to do anything that they don't already know. They know their identification. I don't think this is too cumbersome. It's not really that big of a
If they
deal.
don't do it, does it become
It comes to you got to break the law.
to read off that badge
All right.
number or something awful?
All right. Let's go here. We got. Let's go Senator Cass.
I do want to go.
Let's go Senator Castley, then we'll go to Senator West and Senator Sidnor.
So I fully support the intent of this provision. I think it's just plain courtesy, if nothing else. I don't see what additional benefit comes from the badge number. And my only concern in all this would be that my concern would just be that trying to keep things simple as officers are coming up, because there's a lot of stuff to go over here, and they're coming up to a car, so they're on the highway, they're already dangerous, just from the traffic, let alone from things stopped in the car. So it seems like it'll be a pretty easy litany, unless you were not a very smart law enforcement officer, say, I'm Officer Jones, Prince George's County Sheriff's Department, and I'm pulling you over because you're weaving. That code flows out. You start getting in technical stuff, people make mistakes. I think the intent's good, and I would just suggest that I don't know what we get. If you sit to me and you tell me your badge number or your ID number is 176, unless I'm writing it down, there's no way, it's going to go right over my head too. I'm not sure why you even said it to me. So I think that we're good enough with the name. I'm not sure, the name is just a courtesy in part. What I really know is you're an officer with that police department and you just pulled me over. I probably forgot your name too. So just to keep this simple and flowing, I think we should just take out the badge number. Thank you.
No, I hear you. So just triple checking on what Senator Bailey and Jackson, we looked into this. So every officer has an identification number, which is specific to their law enforcement agency. It may not be a badge number per se, but there is a number associated with a person. So you could say that number, and then If it's difficult to do it like during the time at the commencement of the stop, you could just say at some point during that interaction. But let's keep going. Senator West is next, and then Senator Sidnor, and then.
Okay, thank you, Mr. Chair. So the badge number doesn't make any sense. Nobody's going to remember it. I feel the same about the identification number. Unless the driver has a pen and pencil or a paper, they're not going to write it down, and they'll never remember it. So why are we going to require, as a matter of law, the officer to give it? But my more particular concern is the number 4, the reason for the stop. There may be situations in which it would be much better to get the person's license and registration, and therefore know who it is you're stopping before you give the reason for the stop. Let me give you an example. The car resembles a car that was seen fleeing the scene of an armed robbery a half hour earlier. So you stop the car on the highway. The minute you tell the person, and remember the policeman's out of his car, standing there next to the witness, as soon as you tell the driver that I'm stopping you because your car resembles this car that was involved in an armed robbery, I can guarantee what's going to happen. They're going to floor it and take off and leave the policeman, and he's not going to have any idea who he stopped. He's going to run back to his car. And so if he, first of all, can get the license and registration number, at least he knows who it is he's dealing with. And then he would explain why he's stopping them. And then if they take off, he knows who it is. So I think the requirement of an initial conversation about why you're stopping them in some cases could be problematic.
Thank you, and I disagree. I think the purpose of this is, in total, is a de-escalation. I know I've been stopped in the past before, and the times I've been stopped, it's been closer to what Senator Carter said, license and registration, than me sitting there until they did whatever they needed to do. And I believe I shared with this committee at one time being stopped, and then 10, 15 minutes later being told the reason that they stopped me, which was running through a yellow light, which we all know is nothing illegal about that. Officers, I believe it de-escalates everything when you let people know up front why you're stopping them. There's no issue with giving a name in terms of the identification number. Anytime you call the IRS or some other government agencies, good afternoon, you're speaking to Charles Sidnor, identification number 1234. How may I help you? This is not an undue burden on officers, and I think it's something that citizens should have the right to have. Thank you.
Yes, sir. My question about it, keeping it simple though, if they pull the person over, they don't read off the badge number. They say, "Hi, I'm Officer Jones. I pulled you over because you were speeding." If they forget to do that badge number, then it becomes an unlawful stop, does it not?
That's actually a little bit of the questions that we were talking about back here. So what are the consequences for failure to adhere to?
So you got somebody that gets pulled over, they got a bunch of drugs or God knows what in the car, or illegal firearms, and they're like, "Oh, he didn't read his badge number, unlawful stop."
So I guess, can we go to counsel?
Right. This has come up in other circumstances in the past, I think, for body cams. And if I recall correctly, the case law says that it doesn't create a new exclusionary rule just by being in the statute. So to that, I think the answer is no.
To be honest, Jamie, it was. I think there's case law. I think you're probably right, but I think it's different than I can cite a case right now and tell you that it's not an unlawful stop. I just to prescribe in there. I mean, just to say on the amendment, I think there's some other reasons. Actually, number 4, there's actually a legal reasons why police don't tell you why they stopped you, because the minute they tell you, they've limited the search. If anybody can figure it out, you should ask as a citizen, "Hey, why'd you pull me over?" "Pulled you over speeding." Well, then that's what the point of it was, and that police officers now limit themselves in the search and what they can do. So, but on 2, I just think that's overly prescriptive to do that. And my worry is that if they forget that, which is a small part, I don't know what the average person on the street gets out of that, the badge number. I don't think it's a lot of help, and I think being overly prescriptive and trying to add that in, I don't know that it policy-wise helps a lot, but I think it could just cause more confusion or problems.
My only thing is so someone's been telling me.
And what are they going to say? I'm Officer Jones. 3563244. Oh, okay, got it.
I get that, but also people tell there are 4 Officer Jimmy Jones in the Baltimore City Police Department, and so that's the only problem, that if you're same name, same whatever. But Senator Hellman.
I stepped out, so you may have covered this, but provide to me means the guy's wearing a badge. So we have a broad interpretation of the word provide. So the officer says the person's name. They say, I'm Officer Shelley Heddleman. I'm from the Baltimore County Police Department, and I'm providing my badge number because it's right here on my uniform. Is that acceptable? I mean, it seems to me that falls within the purview of providing.
The Court of Appeals, we don't define it. Because we don't explicitly say, I guess we'll leave it up to the Court of Appeals to decide when somebody gets an unlawful traffic stop and they take this up and fight it, if that means that or not. I would just prefer to take it out because I just think it's overly prescriptive and it's going to cause problems.
All right, you got an amendment motion in a second, but we're still open for discussion. You got Senator Bailey. Leave it to JPR to spend 30 minutes on an ID. All right, go ahead, Senator Bailey.
So I'll try to be as brief as I can. But
no need to be brief. No, I'm just joking, man.
The situation is this, and Jamie, to go back to your point, clearly this is an administrative. If we put this in, this is an administrative violation, right? So all of a sudden, you now have an officer that failed to give his badge number. So he's committed an administrative violation. So by the time this action goes to court, they're going to be going, well, guess what, officer? Now we have this administrative case that we've seen because now that's all going to be released one way or the other, just on the allegation that it was a crime, right? Then all of a sudden we're going to say, well, now we're going to hold this up to see because this officer didn't do this correctly. He didn't do. Now everything that he did here is wrong. This is making something so minuscule, but making it a requirement that it is going to affect the job that is being done. I think that we should move with removing this.
Up to what Senator Bailey had said, even though there isn't a consequence that's prescribed in the law, they'd still be breaking the law technically by not following it. So, they could be subject to discipline in that context.
We just do an amendment and put a number 3 under A, that an officer's failure to comply with these provisions may result in administrative action or administrative penalties or whatever we call that. It's just like an officer's failure to wear his uniform, anything else, that it's just to make it clear it's an could administrative discipline, whatever, could result. And that way we say what it is. And that's the worst that's going to happen. And then I'm expecting that's what we're trying to do here, and not say this is an exclusionary rule or even argue it to be made as such. But if it was just a number 3 that made it subject to administrative discipline. And while I'm speaking, I do have a question on number 1. It says display proper identification. I am concerned on that. And so if an officer's in uniform, does that count? I mean, I walk up, I got my name, I got my badge, I'm standing there, it says Prince George's County Police on my elbow. It's like, I drove up in one of those cruisers. Have I displayed proper identification, or does that mean the officer, each one of these folks has to, before you hand me your ID, I say, here, read this, I'm Officer Jones, take a look. I'm just what that provision means. Thank you.
Thanks. So I don't disagree with what Senator Castley said. In fact, in the Senate bill, we made it clear that these administrative minor infractions were exempted from the disciplinary scheme. I'm not sure if the House took it out in this bill, but I don't think it's an issue because minor infractions are not included or shouldn't be included in the disciplinary scheme. The second thing I wanted to say, Senator Castley, you gave me a look, so now you threw me off. Was that I think you're being a little bit too nitpicky. Like, of course, if you have a uniform, like many officers have a uniform, their ID number is their names that I've seen, their names are not always there, but their identification number is. And for the record, every time I've ever contacted the police department to try to locate or identify an officer, I've always had to give an identification number. I've always gone by the number in addition to the name, so it is important. And then the final thing I want to say is that many officers may not be dressed in full uniform. You know, they might be part of these specialized secret units. And in that case, I would believe that indicating, you know, showing your badge, showing that you are a law enforcement officer because you're in plain clothes or not in police clothes, it would be important. And so I think whatever the identification thing that you have is what is important. If you're in plain clothes, you have a badge, you should show it. If you're in your uniform, you're showing yourself, so that might be sufficient.
I agree with you. If I'm not in uniform, I should have to pull out a badge and show it. But if I'm in uniform, and we have to be nitpicky because what we're putting in this bill is stuff we would normally see in administrative regs, where people sit down and spend 3 years writing it up and agreeing to it with the union and everything else. But we're going to go ahead and put this stuff into the law, so therefore we need to make sure we get it right. And it just seems to me that if to conform with what you're saying, Senator Carter, we should just say, and if not in uniform, display proper identification. Or when not in uniform, display proper identification. And then I would be fine with that, because I agree with you. If you just walk up and you're in blue jeans and a T-shirt, and you're supposed to say, well, I'm a cop, you're like, yeah, right. I'm not buying it. So I'm totally with you. If you're not in uniform, display something right out there, everything else. But I'm just trying to establish that if you're in uniform, that we really need the ID displaying something else.
So I think there was a motion, and I wanted to speak against it really briefly because I just don't think it's too burdensome or onerous for the officer to identify themselves with this identification. It's not like, you know, it's your VIN number on your car or some number that you can't remember. Everybody knows or should know their identification numbers. It's just not too much of a burden. It's really not more of a burden than just saying their name. So for those reasons, I'd ask that we would reject that motion.
Okay, excellent. So we'll go to Senator Sidnor and then Senator Huffman, and we'll talk about if you're going to withdraw the initial one, and then there's maybe a different amendment before us that we can combine a couple things that I think most people agree on. Senator Sidnor.
Thank you. I believe to Senator Cassidy's statement about the displaying of proper identification, my suspicion is, and this came out in the news this summer, you have had officers who were putting tape over their names and their identification numbers. So I think when I read display proper identification, what that tells me is you have your badge number and it's not covered so that people can identify you. I like also what they said in terms of making certain if the officers aren't in uniform, again, they should be displaying something, because we have had cases in this state where people have acted as if they were law enforcement and endangered people. So that's my read of display, and I think that's why it's in there is to make certain that sort of thing isn't happening.
Yeah, trust me, I certainly want to move off of it. Look, there's two ways of being identified. You're either in your uniform, you're in your uniform is your badge and your nameplate. So your name is on your uniform, your badge is there. Whether your badge has a number or not is, it's up to an agency. If you're in plain clothes, you have your proper law enforcement, your credentials that you must have. You have that while you're in uniform as well. But if I pull you over and I'm in plain clothes, I have to display my badge as I'm approaching your car, and then I'm showing you my law enforcement credentials. So you certainly get that. That's part of your training, regardless of what folks are doing out there, or we think folks are doing out there. Secondly, the only thing I'll say is, and I certainly want to get off of this is as far as the ID number. I mean, if I say Corporal Jackson, Prince George's County Officer of the Sheriff, I pulled you over because you were weaving between the lines. What more do you need from that? You need to know my ID. What are we getting from the ID number? Because with MPIA, guess what? You now know why I stopped you. You can get that 911 tape, because I can't pull you over unless, I'm not supposed to pull you over unless I call in the radio stop. I better not, for also safety reason. So That's my piece, and I hope we can move on to, I think we're on, what, page 14 of 66, so.
All right, this really is the last comment on this, and then I got a proposal that I'll put forward and see what people think. Go ahead.
No, I was just going to say, this is important. I know people want to go through it, but with all due respect, this is all new House language. We could have just adopted the Senate language that we spent weeks on, but instead we've got House language that we're dealing with. So I know it's going to be arduous, but quite frankly, we spent weeks going through a Senate bill, which is, gone now in the ether, and we're on to a House bill with new language. And so when I look at this House bill, this language of 2109, which we never had, I don't remember ever seeing this before, that they came up with, is important because when a police officer, every defense attorney now is going to pull the stop, look at it, and make sure all this criteria is done. Jamie is unsure, thinks they won't throw it out, but guess what? They can put the police officer on the stand. Did you do this? Was it a lawful stop? Yes, it was. You forgot to do your badge number. You forgot to do that. You know, they can, I don't know, what is it where they impeach the police officer right there on the stand? Throughout all of his testimony, it was an unlawful stop from the beginning because we overly prescribed what the stop was on something that a badge number, which I don't think adds a lot to a person on the street's information. So I actually think this section is more important than we're treating it.
So I just want to, all right, so based on the conversation, or I think we can find some common ground here. Look, I think it's important to have an identification number because of what we talked about. Several people, different, same names, same department. It just gets confusing. I think it's important for that. You swap out badge number for identification number because that's more universal and applies to all law enforcement agencies. And then you add the language, as was suggested, that this is an administrative infraction. I think everyone was agreed this is an administrative infraction, failure to do this. I think everyone agreed with that. I mean, I remember you spoke up for that this is an administrative infraction, not something that. But I don't think either. But there's nothing wrong with being clear about that. And until we find a case site or something like that to support that. But that's the motion. Folks think. First, all right, hold on. All right, well, we got layers and layers and layers of motion. So, yours is first. We'll entertain yours first, which was just to remove the badge number. What do folks think? Up or down?
No.
You want a roll call? All right, roll call on it.
This is to remove the badge?
Just to remove.
Vice Chair Waldstraker.
No.
Senator Lee.
No.
Senator Castle.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes, and I'm just going to say that with all due respect, right? How many officers that happen so that you get a confusing issue with this when we're talking about a badge number that changes every time, or some agencies that don't even have badge numbers on their badge?
So I guess you're a yes.
I say
Okay.
Senator Carter.
No.
Senator Huff.
Yes.
Chairman Smith.
No. I don't know what it was.
5-6, so it fails.
Okay, it fails. Fails 5-6. Okay, so then we had another one. Do we have one? A second. What was the? So was it mine or was it yours? Oh yeah. So ID number and then administrative, ensuring that it's an administrative infraction. No. Swapping, striking badge, adding ID, and making sure that it is clear that this is an administrative infraction. Do we need to roll on that or? I don't. Senator Carter, what are your thoughts on that? No. On what Senator Castle just said, if you're not in uniform.
What did he just say?
So in number 1, it says display proper identification of the stopped individual, and just insert in there, when not in uniform, display proper identification. I think that was consistent with what Senator Sidnor and I were both saying, that.
And I said I was the one who brought up the plain clothes and you need to show your badge, FYI.
Okay.
Right, and that's fine.
So to be clear.
So is that okay as amendment then, too?
That's fine. Do you understand that? Can you repeat it then?
So it's
one
just
more time?
insert on number 1, insert the words "when not in uniform, comma, display proper identification of the stopped individual."
That's fine.
Senator Carter.
Fine.
Okay.
So, if I sound somewhat resistant on some of these these are things that you're taught at basic academy, basic traffic stops. They try to prepare you for the good, the bad, and ugly of traffic stops, and all that has to do with you deserve to find yourself in an altercation if you don't identify yourself. This is why we teach you to do that, and you're taught those ways of doing that. So, just want to say that. All right.
There's really no need to really respond, but I just want to respond with all due respect, Senator Jackson. If officers did everything that they're trained to do properly, we wouldn't be here right now. Clearly, training is the first step, but enforcement of the protocols is the really necessary step. So I do think this is important. I don't think we're overprescribing given what we're dealing with here. Everybody isn't as great as those officers that worked under you in the sheriff's department.
All right, looks like we're going to do a roll call on this. Let's roll. Senator West.
I think the most important sentence is the last one, but I didn't get exactly what the phraseology is about how this is a technical infraction. What was that sentence?
An administrative infraction. So it wouldn't, just to make sure like exclusionary rule wouldn't apply, no other criminal penalties, nothing else gets chunked out.
The section may not be interpreted to require the exclusion of evidence. So you could say that a violation of the section may not be interpreted to give grounds for evidence to be excluded. No. I think the issue with the exclusionary rule is that we're talking about constitutional violations, and that's the basis for it. So I really don't think that this would apply. There are plenty of situations where things are prescribed by statute, where it may not be followed, but this doesn't relate. It is in the context of a stop, but this wouldn't be a constitutional issue with that stop.
Doing it with body cams, that's not a constitutional violation.
Yeah.
We're still doing it.
All right, so long as you word the sentence to make sure that a failure to achieve each of these benchmarks would not adversely affect a piece of litigation down the road, I don't care what we provide. We can provide anything we want, and if the policeman doesn't do it, it doesn't mean that the criminal goes free. That's my point.
I think that's all of our intent, so.
Dock you $50 because you're not saying the same thing or whatever.
Yes.
We'll move on.
Right, with number one, the uniform is just.
So we're still, are now we ready to move to B? Well, we can't move off of page 14. I mean, this is pretty serious stuff. It says, B says, a police officer may not prohibit or prevent a citizen from recording the police officer's action if the citizen is otherwise acting lawfully. Okay, so here's the situation. You're involved in whatever scenario it is, and a person runs up with the phone and they're recording you. All right? So there's multiple things when you talk about whether it be interference, obstruction, disturbing the peace, whatsoever. And the whole thing is, I don't know how these words can be in the same sentence. Recording the police officer's actions if the citizen is otherwise acting lawfully. The minute that person comes up there and the people that you're dealing with, all of a sudden now they're not listening to you. They're watching to see how you react with this person with the cell phone. And you're like, you need to back up, right? You are affecting what is happening here in this stop, right? And this person's like, you know what? I'm doing this lawfully, right? Well, now you have this attention scenario where you need to be focused on what is occurring right here. You need to tell that person one time, right? Move back. Oh, you can't do that anymore because I'm allowed to videotape you at any time, right? That is clearly an officer safety issue. But the other thing is, now you move from your first stop, because now you've got to get this situation behind you corrected, right? So now another officer shows up. You're like, listen, I need to deal with this because nobody's paying attention to what we're doing at this situation because we've got this other one breaking out over here. Now that person's under arrest. Now the next person's here with the phone. We are creating a monster in this situation where we are clearly saying, by all means, run up there and videotape what is going on. At a distance, back in the area, absolutely. They clearly, and we see it every day, that they can do it. But I just see this as from being out there, I see this be as very problematic as we move forward in the situation of a police officer being able to do their job.
So the way I read it, I mean, there's a difference between like mere nuisance and then like impeding upon the like an investigation or the activities of the officer, which I think would be unlawful. That's the way I read it. But
but I clearly think that's I clearly think what we're trying to do here by the way this is worded is completely muddy that line that is pretty clear the way it is right now. I don't understand who we're dealing with, because we all know that people change. Just look at a voting session in the Senate now that it's all on camera. People change when there's a camera there, and that camera is being recorded. So I think that it's important that when we are dealing with that situation, the people from a distance, absolutely they can record. People coming up there, and I think that the way this is worded, it's, they're going to, all of a sudden you're going to be like, well, they were still 20 feet away. There wasn't an interference officer. It's going to bring a lot to question.
I'll Senator Carter first, and then West, and then Castley. But Carter, do you still want to go?
Mr. Chair, I think you hit the nail on the head. Basically, there's nothing in this language that indicates that the citizen has to be up close or too close to an ongoing investigation, and then all it does is say that, the officers to follow the law. They can't prevent a citizen from recording them lawfully. It doesn't say anything about the distance they have to stay. It doesn't say that they have to direct the citizen like they're doing a documentary. It just says that they can't stop them from doing it. And so I think, with all due respect, Senator Bailey, I just think you're reading too much into this. It's really just a common sense measure, and I think that we should keep it in.
Occurring right now?
Thank you, Mr. Chair. I think we can deal with, I think Senator Bailey has a point, but I think we can deal with it easily with drafting. Why don't we just add the words, if the citizen is not interfering with the traffic stop or other stop and is otherwise acting lawfully?
Lawful order is not acting lawfully, right? So,
I said is otherwise acting lawfully.
but I'm saying if they're interfering, then they're not acting lawfully. Because interfering with a lawful order or an order by a law enforcement officer is not lawful. That's actually a crime. You see what I'm saying? So I don't think it's necessary. If they're interfering, they're not acting lawfully.
I think that you can interfere with the safety, with the officer's safety without actually acting unlawfully. And I look at these videos of people coming up to, the police are involved in a difficult arrest, and people are coming up like 2 feet away from the cop. That's very dangerous. The officer doesn't know if that person has a knife, if they're going to pull the officer's gun, if they're going to jump the officer. Officers ought to be able to say, stay back. You can't, you got to get moved 10 feet back. People who come within 5 feet aren't acting unlawfully necessarily, but they are so I'm with Senator West, but I think if we just add at the end, after the word lawfully, and does not interfere with the officer's safe performance of their lawful duties. So if the officer can say, no, this is, you are now jeopardizing my safety, you got to move back. Well, I'm going to come up and, no, you 15 feet back, or whatever they feel is a safe, they should be able to do that. And it's not to just say, well, they weren't acting unlawfully. I think there is a safety issue here, and an officer should be able to ensure the safety of the perimeter there. So my language would be, and does not interfere with the officer's safe performance of their lawful duties. At the end of that section.
So Council and I were actually talking about this earlier and kind of hit on the same thing. I think it can just say and safely, lawfully and safely, without, with
It'd be right in the police officer's eye. You can't say the police officer has to be able to say you can't shine a light in my eyeball, or.
Senator Sidnor, and then we go back to Bailey.
Thank you. I thought this is essentially just trying to codify what the courts have already held. I mean, this issue was litigated, if I'm not mistaken. I believe there have been a couple cases where a police officer had tried to prohibit somebody from recording what was going on, and at times they were taking people's phones and the like. So this is just saying what the court has already said, that a right that we have, which is we can record what's happening in the public, and we can record what the officers are doing in the public. So I don't see what the problem is.
So the problem, Senator, is exactly that. The fact is, when you're trained as a police officer, even if you are bladed to an individual closer than you and I are right now, if you wanted to harm me with a edged weapon, you can harm me and gain 21 feet on me before reactionary time allows me to even start to draw my weapon to remove it from my holster. So the fact is, when we talk, and you heard people in here talking about 5 feet, 10 feet, 15 feet close to an officer, right? That the issue is that clearly we want people to be able to see what is doing. We want to do the right thing. The police officers want to, but by telling people, absolutely, if there's a stop, you need to run up there and videotape that, and you have that right. When you put yourself in the position of that police officer and there's somebody standing there, and then if you make it nighttime when you cannot see, you can't tell exactly what's in their hands, you've got to stop right here, and all of a sudden somebody over here is videotaping you. It is extremely difficult to make sure that everybody there, you as the officer and authority, are responsible for everyone's safety. Obviously, we know that you're going to be held to that standard. And what we're doing with this wording, I think that the wording that Senator Casserly and Senator West offered helped to clear this up, because of the fact we don't want but they both talked about 10 and 15 feet. We definitely want to make sure that people understand that that distance before they can come there around these officers is extremely significant.
Yeah, this is the argument that they're making in the Chauvin case right now about this is exactly what we're hearing, that the people because they were videotaping what the officer was doing, he couldn't really concentrate on the fact that he was on somebody's neck for over 9 minutes. I mean, I think it's ridiculous. The fact of the matter is, if you're out there performing a public duty, the courts have already said that the public is allowed to record. I mean, that's state law. This is just a codification of state law. And the fact of the matter is, once you start putting in distances, now what's going to happen? So now you're going to have the police coming and then confiscating your cameras and trying to arrest you because you were within 15 feet. I mean, it's just that I think those solutions are going to cause all sorts of problems.
Senator, I didn't at all infer that whatsoever, right? What I'm saying is simply when somebody approaches a scene, when they are videotaping, the officer should be able to say quite clearly, sir, you have to move back right now, right? That person needs to move back quickly. What we are doing, by the way this is worded, right? And this is my opinion of the way I read this. But what we are saying is absolutely I have that right to do it. And you're going to have people that are going to challenge that in the middle of that scene right away. Now all of a sudden we have created much more of a law enforcement presence, much more of a situation by the way we're putting that wording in.
Thank you, Mr. Chair. I think we can solve this problem. I move that we adopt Senator Waldstreicher's suggested amendment, which is to add the two words "and safety," or safely, and safely at the end of the sentence.
All right, we got the the motion was to add "and safely" at the end of the sentence on line 18. Correct me if I'm wrong. We've got Senator Cassidy's light was on. Did you want to speak to that or anything?
I like where Senator Waldstreicher's going. I just there's not there's sort of a difference between being safely can just you don't want to throw any language about interfering with this. It's the officer's safety, not the camera person's safety. So I can say I'm acting safely from my perspective. It's like, whose perspective are we safety? You know, is the safety from? I'm walking carefully. I'm 3 feet from you, but I'm being safe. But it's really whether the officer's perceiving that and he does not interfere with the law, with the officer's safe performance. So it's the officer perceiving a violation of their safe performance of their duties. Just because you're being cautious, I think the safe and safely doesn't really get to it. I mean, it sounds like it's more from your perspective, the cameraman's perspective, and for me, it'll be from the officer's perspective that I would have that right. And to Senator Sidner's point on the common law, those cases almost exclusively involve people who, I mean, like the guy with the motorcycle with the camera, the GoPro, he's just sitting there as they turn the camera off. Or somebody with a dash cam who's not moving, they're not doing anything different, so they're just saying, turn your camera off. That's different than, which is where I think the bill was probably originally going. I have no problem if that's all we're doing is to say you can't say turn off your GoPro during the arrest. It's already on, you're not changing anything. To me, and I thought Senator Bailey made a good point of this, that's one way to look at it, but its expansive reading says people are coming up to the officer with the camera. If I don't have a camera, can the officer say stay back? But if I have a camera, does that give me a license to come up within 2 feet of the officer? That's the challenge we face on this. And the officer ought to be able to require a safe perimeter. And the fact that you have a camera doesn't mean you don't have a camera and a knife and a gun and a razor. I got you have a camera. So I like Senator Waldstreicher's language, but I'm not sure it's quite broad. I don't know if it does really, really need to go over the saying and safe, you know, the officers' safe performance of their lawful. I'll defer whatever the committee wants to do on it.
Yeah, so I just want to remind everybody just a couple of things. One, you know, citizens have a right to witness lawful and unlawful. That we are allowing that officer to control the scene to provide public safety. So, you know, the fact that someone pulls out a camera phone and films me in the performance of my duty is one thing, but you know, I have to have the right to be able to say, look, you need to stand back a little bit. You know, I can't get distracted while I'm trying to, you know, control the circumstance and bringing something, you know, de-escalating a problem. So I don't think we should be really arguing about, you know, whether a person has the right to use their phone to film you. I think we just need to make sure that, you know, the officer can still perform the duty that they're sworn to do in a safe manner. And how do we get to that with this language? I mean, if you know, how do we, and I'm sorry, Mr. Vice Chair, I wasn't paying attention. I was speaking to council about another bill, so I didn't hear what you offered. I'm not opposed to someone filming folks, you know, officers in the line in performance of their duty, but I am. I just want to make sure that everybody understands that there are boundaries that we shouldn't cross. So.
You're not okay?
I'm not supporting that.
Okay. So, everyone, anyway, you're down and safely? So we, all right. So how many downs? Let me look. Who's down?
I'm only down if my motion.
That's not your motion.
Wait. What is your motion then?
I just wanted broader language. My amendment was instead of just the word safety.
Can you get Casley?
It does not interfere with the officer's safe performance of their duties.
Well, I don't want any passing, so think yes.
What's that?
Think his.
His just says safely.
All right. Looks like the amendment passes. All right. The amendment passes. We had two. Good.
Like what I would characterize as the ridiculousness of that motion, I'd like to make a motion to add the language that an officer must safely approach an individual to perform a traffic stop and safely make sure that they're not impeding traffic in so doing. It is absolutely overprescribing to add safely, which is inferred already. And I'm making that motion to highlight how ridiculous it is that we're nitpicking and we're overprescribing. I'm embarrassed that we would think that would be something we should add to the law. We don't add the word safely to any other laws that we pass. So, I mean, unless we're going to prescribe the officer must safely approach, because oftentimes they're impeding traffic when they're pulling people over, then I think that was a ridiculous thing to do just now.
We got Vice-Chair Wallstreicher, and then we'll go with Senator.
Okay, so just to be clear, my intent was not to do damage to the bill. We do add safely to laws. We just added safely to Senator Sidnor's bill when it came to body cams, and that's where my idea came from. When we passed Senator Sidnor's bill, we explicitly amended it to say when safe to do so. And so my language was an attempt to mimic the language which you supported on police body cams. So my intent was not to do damage.
Safely approach an individual to begin with? I mean, why are we overprescribing what the citizen, with the officer's ability to stop a citizen from exercising a legal right when we're not overprescribing what the officer must do? And I'm very, very serious about this. I mean, it is implied.
Yeah, look, we crossed the Rubicon on this one a while ago. What we are doing now is what we otherwise would have done by administratively through the Police Training Standards Commission. But this body decided, or at least the other house decided, that we were going to go ahead and micromanage this process. And so we are now what's normally done, we normally refer to as drafting regulations, which involve minuscule and close attention. Normally we would say, Police Training Standards Commission, go establish standards and training and all that for this. We didn't do that. We're laying out in detail, and I don't agree with this process at all, but hey, we're stuck in it, where we are now prescribing how policemen get out of their cars and walk up to people's cars. Is that absurd? Absolutely, that's absurd. But hey, here it is. So because we're all going to be stuck with drafting regulations, this is how boring it is and why legislative bodies don't usually do it. We usually say let somebody else do it. So welcome to administrative regulations.
Well, admin law was one of my favorite classes in law school. Right?
I was the number one guy in my class for admin law, so it's not like we can't do it.
I got it. No, all right. Keeping in mind we have nothing in front of us right now, but go ahead, Senator Sidner, go ahead.
Thank you. And I just wanted to point out to Senator Castley that in Senate Bill 589 there was a section that in looking at this type of language then said that the commission shall develop standards to implement the requirements of this language. So.
So starting on page 15 and into page 16, this part of the bill establishes the Maryland Loan Assistance Repayment Program for police officers. The office is required to distribute and under the required to distribute funds from the program to assist in the repayment of a higher education loan owed by a police officer who receives a graduate, professional, or undergraduate degree from a public college or university in the state, obtains eligible employment, and satisfies any other criteria established. It requires a $1.5 million appropriation in the state budget.
Senator Hettleman.
I hate to do this, but I have a question on page 18, line 7. So you sign a letter of intent to perform the service obligation on completion of the studies? Why would you not do that prior to or at the outset of your studies?
Not signed letter. I use that as from the service to completion. Sign the letter to completion. You signed the letter before.
No, but you're getting this scholarship, right, based on service. Or is this like a loan repayment in exchange for?
So it's actually two different
two separate things. One's a scholarship.
Things. There's the loan repayment program, and then there's actually the scholarship program.
Right, but if you get the scholarship, then you're obligated to for service, right?
Right.
So why wouldn't you do that from the outset?
Do what?
You're signing that you're intending to do service in exchange for the scholarship, but it says here, upon completion of the studies.
So that's when your service obligation would begin.
Right, I understand.
But the letter that you're signing is you're signing that as a recipient of the scholarship.
Right, but the scholarship is paying for the studies that you just completed?
They're paying for the studies that you're currently enrolled in.
Yes, but you've just. But you. Yeah, that's what I'm saying. I'm suggesting that sign a letter prior to the beginning of the study, not upon the completion.
No, I think that what that's in reference
missing?
to is that your service obligation begins at the completion of your study, not that the letter is being signed at the completion of your study.
To perform.
So I'm going to give you your scholarship, but here's what you have to do. Before you got to be a Maryland resident, you got to do all these things, including signing that letter. I mean, to me, that's clear. It means here's your scholarship. You want it? Yeah. Well, you have to meet all the criteria. Did you sign with those letters? Now you don't get the scholarship. because a recipient shall.
Okay.
I mean, I have no problem if you think there's ambiguity, but to me, it's clear that he has to do it before he signs, or before he gets the money, or she.
Okay, move on.
All right,
you.
Senator Bailey.
Since we're on page 18, might as well go there. I wanted to go to line 5 and 6. And we're talking about eligible institution as a full-time or part-time undergrad or graduate, subject pursuing a course of study or program in criminal law, criminology, or criminal justice. My question is, why are they the only three areas of study that this would apply to?
My only other is because it's relevant to the profession that they've committed to going to in satisfaction of the requirements for their scholarship. But look, I see where you're going with, but I mean, I don't know if you go somewhere and you get a basket weaving degree, it may not necessarily be relevant to your.
In all seriousness,
No, I'm serious. I'm serious as well.
Right. Both Senator Jackson and I went to Johns Hopkins. We both got our graduate degrees in management. Both of them centered around police departments, and we would not have been eligible or available to do that. And the fact is, when we talk about criminal justice, criminal law, or criminology, we're talking about the officers that are on the street. We're not talking about the management professionals that run the police department. And if we want policing and things to get better, clearly that's what the incentive and the initiative is, so that we can make the police departments more professional. So people that are moving forward in that line of work and can have that degree, such as management, and there are other degrees, there are other electives that would qualify just as important, they should be included in this. So I think that it's rather restrictive just to say, well, it's one of these three, or else. We should open that up to be more open in that degree. If we're really talking about the fact that we want to make police departments more professional, we want to deal with management, we want to look at the different things that exist, this should be more broad than just those three issues.
What's the will of the committee? Senator Heldman, you got something? Senator West. Yeah.
I would make a motion to that the course of study be any course of study that would further that of the police department.
Career or the police department, like the.
What's that? Yeah. To deal with management or leadership.
Do you want to add management or leadership to that, or do you want to be more open-ended?
Psychology. I mean, I don't know that I want to open it up, but I'm just throwing it out there. Learning about sort of the psychology of human beings would be probably productive for a police officer, but I'm not sure.
I can't hear you.
Road. I said I'm not sure I want to open this up, but I was suggesting that learning about psychology would be extremely helpful.
Right.
So I'm just not sure how far and broad we want to go here.
I don't disagree. Psychology would be. I think management and leadership clearly would be 2 degrees that would be, when we talk about the professionalism, if that's what we're really doing, that's what we should be talking about. I just thought the 3 was very restrictive.
I second it. If we second it, I second that motion. I don't know why we're overly prescribing here. I mean, I'm not
we're not the Board of Regents or UMD or whatever. I have no idea which way you rank classes as a thing or not. I mean, when we talk about,
That's the main thing. They gotta be cops.
We got Senator Bailey, Senator Weston,
so the whole thing that we talk about, and when we talked about police reform, the one thing that's been clearly missing when we talked about what was the intent, and when we looked at police departments across the country, the departments that have the least issues when it comes to internal affairs, the least things, they are the most highly educated. They are the ones with a 4-year degree. And that degree doesn't have to be in those departments. It doesn't have to be in one of these specific 3 issues. And so that's what I'm saying. I mean, if we're really looking for the qualified, if that's what the intent of this part of this legislation is, then it should be open enough. And then, because I mean, what are we going to do? Is this where we're headed to a pay incentive like we do for our teachers? Is that, I don't know where we're headed, but I do think that we shouldn't pigeonhole ourselves right at the moment.
Thank you. Let me try out some language. Pursuing a course of study that would further the student's career in law enforcement. Does that work? Okay. I've moved that language.
Everyone's fine? All right.
I'm sorry. Course of study that would further the student's career in law enforcement. Okay.
It's 19 and 21, or 19 through 21.
Yeah, that's fine. I'm just trying to get us to move forward on this bill.
So we have Vice Chair Walter and then Senator Cassidy.
So when we were conforming that, I noticed that page 17 refers to a 4-year degree, which seems to imply an undergraduate degree, but page 18 where it exists, it says an undergraduate or graduate degree or graduate student. So,
Yeah.
well, it's just a question of policy. It says one thing on one side and one thing on another. We just have to choose.
Undergraduate and inclusive. We should do undergraduate and graduate.
Okay.
Yeah. Senator Cassidy. So just to be, the intention was for undergraduate and graduate school, so we should just make them uniform.
Same.
Yeah. Senator Cassidy. Yep.
So just real quick, the testimony by both, or the advocacy by our 2 police officers over there, they talk about going to Hopkins. On page 16 in lines 14, this restricts us to public colleges and universities in the state. Is there a reason that we want to restrict it to public? And I mean, about colleges and universities in the state, I don't know why we want to. I mean, my motion would just be to strike public.
Yeah, let's ask council if there are any other ramifications for setting up a program like this for the state system vice private schools. Just give them one more second. And
Yeah, I'm just analogizing it like an ROTC scholarship. You can go to University of Maryland or Hopkins or Loyola or anything on an ROTC scholarship, and it's all federal money. So
then you get into spiral for-profit colleges, all that stuff.
Yeah.
It just spirals down to the for-profit.
Well, you have a board that has the option to fund these or not. So you get it's not an automatic.
All right, Well, here's the most important decision you're going to make tonight. I'm going to circulate a menu. The question is red wine or Galway Bay? That's not an option until after we finish. Galway Bay it is. If you could initial just by your order. We're debating the two menus. We're going to do a roll call on this one, all right? She's not impressed. All right, we're going to do red. So the question was about, are there any other like unforeseen, are there implications for private, like the public school system vice private schools if you were to just open it up in terms of the allocation?
If you open it up to private institutions?
Yeah, just let's flag it, and then if you could check with someone, I don't know. We'll come back to it.
We won't do it. If we just strike that, if we just strike the word public and don't put private or anything, just scholarships, they'll award them where they can. They won't award them where they can't, right? So we don't really have to resolve it. Because you set up the scholarship board, and they obviously can't give a scholarship where it can't be given. So just remaining silent, we give them the discretion at least.
I'm just like so nervous about like you're enrolled in what's a matter you that's a private for-profit school that rips you off at the end of the day, and then all our state money went toward it. I mean, just
I got it.
yeah.
But that's the beauty of having a scholarship board is they can say, no, we don't do to that place. You can't. We're not going to pay there.
So I think if you look at page 17 and line 6 and 7, that's what an eligible institution is. So it is defined as a public senior higher education institution in the state. So you would, I think, be affecting eligibility for the institutions. It doesn't seem like there'd be a whole lot of discretion there as far as which institutions they would say qualify, because I think the statute's doing it.
We'll come back to Senator Jackson.
Thank you. I just want to give a little backdrop. So when I retired from the office of the sheriff, I went to work for Governor O'Malley, Senator Carter, and I did leadership development for public safety across the state. Part of what we did was public institutions in the state would offer educational opportunities for training and retraining opportunities for public safety. And because there were public dollars, Senator Castley, that's why that focus then was on the public institutions in the state of Maryland. I will say history has proven, and that sort of went off the rails, I think, when the leadership development piece came along. Baltimore Police Department had some of the most, when you look at numbers-wise, highly trained or educated law enforcement officers, because there was a program within that agency that if you wanted to attend community college, undergraduate, or graduate school, there would be a reimbursement if you maintain a certain grade point level and you took enough credits, a certain level of credits. So if you were a command officer, and they would pay a portion of it. If you were a line officer, they would reimburse it all. And that went away during the O'Malley era. And this was part of the leadership development piece we were doing, was trying to restore that as well. So the public institution, we're talking about public dollars. Prior to coming to the Senate, while serving on the House work group, this was introduced by a delegate from Baltimore City, and I think this was sort of trying to get that back in to try to attract folks and to, look, move in the direction of professionalizing law enforcement, professional employees require employees to be trained on a regular basis, reach a certain education level. And so if we're going to professionalize or help to maintain the professionalism of law enforcement, I think that was the intent. I just wanted to throw that out there. So.
Let's keep marching. Page 20 or 19.
So if you go to bill page 20, this addresses the liability caps. On page 20, this is the Local Government Tort Claims Act. Beginning on page 21, it provides that if the liability of a local government arises from intentional.
We went through this discussion in this body. I simply make a motion that we strike everything on page 20, line 25, through page 22, line 21, and put this in the same posture that we had our bill, where we decided that we were not going to address liability issues this year, that's not part of what we were doing, and just move forward with the substance of the bill. Because this piece is going to take a lot of time. It should be subject of its own separate bill next year if people want to. We've dealt with these issues previously, and I think we had, within the Senate, had decided, within this committee, had decided this wasn't an appropriate year for this stuff. So that's my motion, to strike those pieces.
Yeah, absolutely. There's been a motion to second. I'll speak on it afterwards.
So in the House has our bill, so presume they could restore it and send it back over. So I second it, because we've already dealt with it in our legislation. In the hours and hours and hours we'd already debated on this, and we've already dealt with it. So if the House doesn't like it, they can restore it in our bill and send it back over.
So obviously, I was a sponsor of the two bills on this side, and I agree with the policy, position. So you've got an amendment before us. You've got a motion before us that's been seconded. We'll roll it, and if it fails, it fails. If it rises, it rises. Then we, keep debating. So go ahead, Senator Hedelman.
That's what your bill does in comparison to this.
It's the same basic concept. And then do you remember? The attorney, Kerry Hansel, he came in, he gave some pretty good testimony, and then we went back and forth about what impact raising the caps would have on, there were some specific concerns about smaller municipalities, then we went into the insurance regime, legit, went back and forth. It's refreshing a little bit. So, I'll just read some from my testimony or their testimony. So, the point is, under the current, I'm just reading this from the testimony. So under the current law, the Government Tort Claims Act is limited. It's capped at $400,000, and the same cap applies to both economic damages and non-economic damages. In violent cases, however, the actual out-of-pocket expenses, like lost wages, property damage, medical bills, exceeds that cap. In this way, the most seriously injured people are victimized twice, by the underlying misconduct and then by the laws that are limiting fair compensation. So obviously, remember we talked about the medical bills exceeding the caps and then this weird, perverse kind of outcome that happens. So that was the kind of the framework of the debate that we had. I don't know.
The caps on your bill and the caps in here are the same.
Same. We did not pass this. No, the caps are the same though. It's the same language.
Yeah.
It was a cross file initially with my delegate.
Thank you.
So it looks like the word intentional has been added prior to the words tortious acts or omissions, which would really limit the circumstances in which this would be applicable. But I don't understand the words that follow. It says, or internal or unintentional violations of constitutional rights. What are internal violations of constitutional rights? Does anybody have any idea what that means?
So, oh, sorry, that's supposed to be intentional, that's a typo.
Yeah.
It was intended to be intentional.
Is that new language that was added that was not in the House bill, or was just a mistake the House made when they passed this?
No, that is new language in the amendment.
Excuse,
I think Senator Castley has a motion on the table, so I'll come back to it, but I agree with Senator West that that it's unclear what an unintentional violation is. If it's unintentional, then there is no violation. And so that might need to come up, but I'll make that motion after we vote on Senator Castley's, or Senator West, if you want to make that motion after Senator Castley's motion, because the language is deeply unclear to me there.
Okay, so there's a motion on the table, and that's to strike, basically this provision. So it's from page 21 to. Yeah. Okay. To page 22. Sure.
question, really. What is the local Tort Claims Act limit or the state Tort Claims Act limit, irrespective of this, outside the four corners of this bill? Is it $890,000 or something lower or something higher?
Claim and 800,000 per total claims under local, and the same. It's 400,000 for single claimant. This is state 400,000 to a single claimant for injuries arising from a single incident or occurrence.
So
under the state.
So this is establishing a totally separate tort claims limit in cases of police misconduct. I guess my problem is we haven't had any testimony on this. Do we know we're going to apply this to all the counties and the municipalities across the state? Do we know what they think about this?
No, we did have testimony on this, and you remember they brought in Mako and MML brought in their the administrator from Legit. Do you remember that hearing?
I don't remember it. Was it one of the bills we considered, one of our policing bills, or a separate bill?
So it was part of an initial conversation we had with one of the two bills that I had that dealt with this issue, and it was right at the very beginning of session.
Okay. And did they? I assume they didn't like the idea that they would be opposed to this.
Their testimony, I don't know what they've done here, but I remember they came out with opposition, and the administrator from Legit spoke to how the insurance regime worked, and so I think Mako and MML came out opposed, right?
There was a letter from Mako. Let me just pull up the relevant provision here.
Did they testify for the House bill?
So I don't recall if they testified in the House, but I do have a letter from Mako here. It says county and municipal governments continue to disagree that added liability exposure will result in reduction in individual officer misconduct, exposing maximum liability to an agency. Essentially, the argument was, or the rationale was that, like in a, this may have been from MML, that if there was a car accident between a person driving a garbage truck, for the municipality and another vehicle, that would be treated differently than I think their letter mentioned that would be treated differently than a police officer getting into an accident with the same person. So that was their rationale for objecting to it.
Mm-hmm. Maybe this is imprudent, but to the chair, have we been charged with passing out this part of the bill, Or would there be people upset if we deleted this part of the bill?
To be honest, Chris, we're our own body, but we should just, we're the Senate, man. We should do what we want to do. Come on, we're the Senate.
Okay.
We don't have to take orders from the House.
No, I was referring to Senate leadership,
The Mako.
I like that attitude though. 90% of the time, I don't know, until it gets me jammed up. But it's cool. All right, Senator Castley.
Jimmy hit it square on there. The reason we put this out was that there's no suggestion that if you if you say to the municipality, your cap is here versus here, that's going to somehow make police officers not violate people's rights. I mean, the liability, this is the municipal liability. They don't want to pay, they don't want any liability. So to say, well, now it's 800 instead of 400, well, we were going to be careful at 400, and now and the officer's like, well, this doesn't apply to me anyway. If I was going to beat the crap out of you, I don't care how much the municipality has to pay. I care whether I go to jail and whether I had a personal judgment against me. So this has nothing to do with the officer. It has everything to do with the municipality. And because of that, because there's not a direct nexus between the incidences of police misconduct and how high the cap is in the municipality, it was inappropriate for this entire statutory scheme. And we ought to bump it. And this bill relates to police misconduct and or alleged misconduct, inappropriate actions. And this particular piece of it is not at all, it doesn't belong here.
So I just wanted to follow up on that. What I read was me reiterating and reading from the letter from Mako. But I guess I did in my email find something from Mako. There was a suggestion that, and I'll just read it verbatim. They said the following limits on liability apply only to judgments entered upon a finding that the law enforcement officer committed an intentional tort or a violation of the Maryland Constitution or Maryland Declaration of Rights while acting within the scope of employment with the local government. That was their suggestion for the scope of the tort caps.
So look, I think that's a correction that we have to make if we are going to keep this. So let's roll it. It's been seconded. Roll it first, and then. All right. So we're gonna roll.
Vice Chair Waldstreicher.
No.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Chairman Smith.
Nope. Senator West.
Okay, that amendment
Fails.
fails.
Yes, so I propose on page 21, lines 5 and 6, I guess just line 6, changing internal or unintentional to intentional, and making the conforming change over on it's page 22, line 2.
Just to be clear, what we're striking out is on line 6, it says tort or tortious acts, and then strike out or internal or unintentional violations of constitutional rights.
No, we're striking internal or unintentional and substituting intentional.
So it's intentional tortious acts or intentional violations of constitutional rights?
Right. I've forgotten all what I was going to say.
Exactly.
With, so if we were to adopt the change, and I'm looking at the change on line 6, which I know one is because of the, I guess, a misspelling, but if you remove the unintentional violations of constitutional rights, I'm curious, what is, do you know what the remedy would be if we're talking about unintentional violations? I mean, does it just, yeah, that's the question.
I mean, I guess the question then is like, what type of behavior you're trying, or what are you trying to incentivize or disincentivize? What type of disincentive are you trying to provide by making the jurisdiction more liable? So I mean, if it's unintentional, is that something? I mean, that's the policy conversation. Like, is it something that we're trying to? Is that the behavior we're trying to curtail?
Of anyone's constitutional rights. That's what we're trying to curtail, whether it's intentional or unintentional. We don't want our citizens' rights to be,
of course,
constitutional rights to be violated. And so
but if it's something is unintentional, then how is any sort of disincentive going to correct that behavior because it's unintentional?
Mr. Chairman, my next amendment that I propose is, we're still on page 21, on lines, to delete lines 11 through 13, which is the automatic escalation. I think taking it to $890,000 is substantial, and if we want to escalate it, we should come back and not submit to an automatic escalation clause. So just simply delete the lines 11 through 13 on page 21.
I was trying to figure out, I'm actually very concerned about this part because with all due respect to the senators from Baltimore City and Baltimore County, you're from large, wealthy counties, you have a unified police force. I have towns that have a $2 million budget that have a police force. And what I don't want, and I would think nobody here would want, is all these small municipal police forces, which are actually the best. I mean, they are. I mean, our police chief actually, unfortunately, Brunswick, he actually passed away today. And there's a huge outpouring for him. I mean, everybody loves this guy, and it's a local police force. You know all the officers. It's really a great thing to have. It's one of the pluses of living in a small town. And I'm concerned about that you go to a town of Brunswick, which has a total budget of $2 million, and then we're adding more liability. And it's not just them. I've got Thurmont, I've got Mount Airy that have their own police forces. Carroll County, which I have a small part of, has like 5 or 6 police forces. So I am very concerned about the liability cost. Whereas Baltimore City and Baltimore County can cover this, I'm afraid that these small ones, you know, the insurance costs will make them to say, we'll just get rid of our police force and go to a resident trooper. So and it seems to me we're going from 400,000, doubling it to 890. I mean, and by the way, the 400,000, we already just dealt with this. This was a couple of years ago. We went to the 400,000. I mean, my county executive was very upset. I voted against doing it, but when we went to a torts claim, we did that during the last police reform 4 years ago. We dramatically increased it. So I'm just concerned with this whole section, going from 400 to up to this, and then adding every year, when we just did this to all the counties. And I think the outcome of this is going to be very detrimental to community policing. So I would definitely second the motion, at least on the 15,000, but I think we should even discuss the 400 to 890, considering we just did the 400, just went up.
It was our first year. I was in the House when we did that, so it was our first year in the legislature together. I think it was 16.
It was the first. It was after the death of Freddie Gray. It was the first year of police reform, which I want to say
16.
Yeah, like 2016. So it would have gone into effect 2017. So you're looking at 4 years ago. I think we may have doubled.
Actually, I think it was 15 because it was the first year of the Hogan administration. He sort of cut his chops on the Freddie Gray riots.
Yeah, but we wouldn't have taken it up till 16,
Yeah,
and it
right.
wouldn't have, it wouldn't have, so.
So what is the argument for increasing it from 400,000 to 890,000 that only covers police misconduct? What's the argument for that? Other than the fact the House passed it.
You know, again, I'll just read again from the testimony, just that it's the out-of-pocket expenses, like lost wages, property damage, medical bills, exceed the cap. And so you're left with this perverse outcome when folks are injured. It's just not enough, and not enough to cover their out-of-pocket expenses.
But with all due respect, if you look at the brutality cases that have been happening, the high-profile ones, they've been millions and millions and millions of dollars, the settlement that the city has done on those.
But, Mr. Chairman, if you're, to address your concern about medical bills, which is legitimate, that if you know, the guy's really in the hospital and he's really, you know, got stitches and recuperation, but this goes economic and non-economic damages. So you could say, well, you sprained my wrist and that cost me $40 for an air splint. I had to wear that for a week, but my pain and suffering was just so great, and so now you get $880,000 for a sprained wrist. That's what this allows, and that's the risk of this. I mean, if you want to address your concern, which I have much more sympathy with, then you just simply apply this cap to you extend the cap for your economic damages, but not for your non-economic damages, and that way you make sure that this kind of escalation is going for people who are truly physically, you know, serious physical ailments, and not simply their non-economic damages, which could be the bulk of what's happening here, which would, I'm afraid, you know, you don't get many cases where there's over $400,000 in medicals in these instances. It's the non-economic damages that are going to escalate this stuff in most cases. Most of these cases don't involve much lower level of injury than the you know, really serious bodily. So you're really going for the non-economics. So if we're going to hold true to that, then I would suggest that we strike the non-economic damages out of this escalator, or I'm sorry, out of the extension of the cap.
So I guess the rejoinder to that is that you got, like, so for wrongful death, medical malpractice, personal injury, there are caps which are considerably higher than the ones we're talking about here. I'm just leaving off this thing in, and then, but. For those categories, there's no limit on economic damages. And I guess the second thing for what Senator Huff was saying, look, and counsel, correct me if I'm wrong, you get these crazy judgments, you're still going to be drawn down to whatever the current caps are, the limitations of the cap. So I know that the juries will give it, but you're not.
But recognize that in medical malpractice actions, the hospitals prepared for that. But hospitals are prepared for that, as are doctors. That's why they have insurance policies that cover millions of dollars, and it's also why they only perform their practice in an isolated operating room that's everything's controlled and no one else is allowed in except for the doctors and the nurses, and they carefully control every little piece of the situation. And the challenge with policing is you get none of that. You're out on the streets Everything is fluid. It's very difficult to control. You have none of that control you have on the medical malpractice side. And so that's why you try to limit this, because the exposure is so high that, look, we are going to result. It's just like when we don't have monkey bars on playgrounds anymore. We have little swing sets on playgrounds. A lot of municipalities don't do football because there's a liability exposure. And don't think that won't apply to policing. You will reduce policing for this. People will get rid of certain higher risk aspects of their police departments. They will tailor back their conduct, but it's not necessarily a benefit to the public, because you're saying, let the bad guys go. Don't just, it's going to cost us too much. There's a higher risk when we do those things and try to get the bad guys. The bad guys will benefit from this as the costs go up. If we were to say, look, this is to justify what you all have said, then you would take us at economic damages to make sure people aren't just left to suffer on their own when a policeman does an intentional act, and that would truly cover that. The idea of discouraging, you're not going to discourage bad behavior. What you're going to do is discourage good policing. That's what we're going to do. We're going to have low-risk policing, much lower-risk policing, and that's what they're going to have to engage in. And low-risk policing means a lot of other bad guys get away.
Well, if I could just make my point, I was saying is that the larger jurisdictions, which have had most of the incidents, have been in the more high-profile bad incidences have been in the larger jurisdictions, and in those cases, the county executive and the mayor straight up appropriated, large payouts, which they can do. But if you go to some of the little towns in Western Maryland, they cannot do that, and they're the ones that's going to bear the brunt on this. So at least, if nothing else, we should not put in automatic escalators into these bills. People should come back and make their case why they need a bill down the future. So I think that was a sensible motion, and that's why I seconded it. I would like we just vote on striking 11 through 13, which is just getting rid of the escalator that every single year goes up by $15,000.
I mean, that language is borrowed again, and Heather, we've gone over this a bunch with the tort claims for employment discrimination. We did that I think that we borrowed that language from when we did the reform in 2016, 15, whatever it was. And then we did it again here in this committee with employment discrimination claims, and we brought it down to a percentage. You remember that, Senator Cassidy? But Senator Heddleman.
Well, wait a second. I have a question on that. Yeah. I thought when we did this in 16, they just straight up did the amount. They didn't add amount every year, did they?
I don't know, Heather, you may know this better than I thought there was an escalator clause in that when we did the tort claims reform in 2016. I know we used CPI for the latest bill we did in this committee, but
I think that was an amendment that had been proposed. I don't think that was actually part of it. I think you're thinking of malpractice claims in the court's article that has an escalator.
No, because you have it right here. You have the amount is $400,000, which is that was. I'm pretty sure they doubled it from 200 to 400. So I just think I got qualms on the 890. We can debate that next, but I just think the 15 to automatically increase every single year. What is this from now to infinity? That's just a bad practice. People can come back in and make the case.
So, Senator Hellman.
I was looking and wondering. I'm assuming, and I don't think I have to assume. I just went back to look at some of the testimony from your bill. And look, it says here, smaller jurisdictions have below market rate insurance through the local government insurance trust. And then I'm assuming that each county, as well as the city, has insurance for just this reason, correct?
So that's the conversation we had with Legit. And then, so I guess I only learned a little bit about this, so I'm not going to purport to give you a full-throated answer. But I remember, so Baltimore City, for instance, they self-insure, right? Senator Carter, and yeah. So there are different regimes across the state. Some jurisdictions have Legit. Some jurisdictions, like Montgomery County, I think, have something different. So I don't know, I don't know the answer to the question, but it's different. It's different.
You would just think that there's less people, unless they pool with other small towns, but it's a smaller insurance pool that they even have. I mean, you're only insuring that I don't know exactly how they do it. I know in Frederick County, we did the last tort claims, they were really upset about it. So it's harder for a county like even Frederick County. I don't even know how you get in these municipal police forces. Even if they all band together, It's just a smaller pool. And not only that, it's less wealth in those areas too. Montgomery County is completely different, the amount of wealth that they have compared to some towns out in western Maryland. I mean, like I said, this Tort Claims Act is going to be almost as large as some of the general funds for these whole towns.
There's no, I mean, look, I think there's no doubt that if you get schwacked over the head with one of these huge judgments, your premiums are going to go up. So.
Just remember that in these cases, because this is an intentional violation, of course, now the officer's subject to personal liability, but he's also subject to criminal penalty because he intended to violate somebody's constitutional rights. There's the biggest disincentive to engage in intentional violation of constitutional rights.
So the smaller municipalities and counties are already covered by the existing language which caps their liability at $400,000 for an individual claim and $800,000 for total claims, right? If that's the case, why don't we, I think there's some validity to Senator Huff's concern about about small, poor counties and municipalities. Why don't we limit Section 3 to certain named large, wealthy jurisdictions? And I could come up
excluding Montgomery County, of course.
No. You don't get out of it. But, Montgomery County, Prince George's, Baltimore County, Baltimore City, those are the ones that would obviously come to mind. And the state of Maryland would be another. I think the obvious next ones would be Howard, Hartford, and Anne Arundel, but they're much smaller than the four I mentioned. And that way you exclude all the local counties and the little municipalities like the town of Brunswick from the effect of this.
As a matter of policy, I don't agree with that at all. I mean, if we're going to do that, then we do some sort of pooled fund or something. But I don't think that if somebody is violating somebody's constitutional rights and, and they happen to be employed by a smaller jurisdiction, that they should be held any less accountable than if they happen to be employed by a larger one. I think that the jurisdiction should be on the hook for their behavior, regardless of the size. Which is the amendment? The amendment is what?
Right, it's to get rid of the escalator. So, right, 11 through 16, actually. And then a conforming change with the state tort claims.
So the framework's still there, escalator out. Some jurisdictions are too legit to quit. Oh, come on, that was a good joke. That was a fire joke. That joke was fire, all right? That's that Matt Jackson joke.
You're more humorous than our Senate president.
It's all those dad jokes are catching up, man. All right, Senator Castley.
In lines 8 through 9, to provide that the 890,000 limit is for economic damages, and that non-economic damages could not be more than the 400,000, will be subject to the $400,000 cap for a combined 890.
On claims arising under a single event. Just keep it basically the same as it is now.
I'm sorry?
Keep it the same as it is now.
I'm trying to limit the 890 to apply to economic damages.
Yeah. But for
Not-
non-economic, keep it as it is. Yeah.
Yeah, I'm sorry, for non-economic, keep it as is, except that I don't want to have 890 plus 4. It would be 890 max for the two. So it's 890 for economic, 400 for non-economic, but a maximum award of both would be 890. Otherwise, you could get the 890 plus the 4.
Got it. So, hold on. Let's have counsel repeat that when he's working on something real quick, but he'll repeat it.
Correct me if I'm wrong, the amendment would just be to strike non-economic?
No, it kind of leaves lines 8 through 10 together as it is, because it says the combined award for economic and non-economic may not exceed a total of 890, and they have to say, and the max award for non-economic damages would be the 400,000, of which no more. So basically, of which no more than 400,000 could be non-economic damages. Of the 890, of which no more than 400,000 could be for non-economic damages. Would insert that. So you'd had to have, it keeps the 400 on for non-economic, and then, so of the 890, the max for non-economic damages would be 400. I'm sorry. My feet are tangled up in this. Cords under here.
So lines 8 through 10 would now read, subject to item 2 of this item and item Roman 2 of this paragraph, the combined award for both economic and non-economic damages may not exceed a total of $890,000, of which non-economic damages may not exceed $400,000.
All right, so it's an motion. And second, we'll just roll it.
Vice Chair Waldstraker.
No.
Senator Lee.
This is to strike it out. To strike it out.
Jamie, do you want to re-explain it?
Jamie, is this to strike it out?
It's not.
No, Senator, it's not to strike it out. It is, the language would now read, subject to item 2 of this item. I'm looking at lines 8 through 10. It would now read, subject to item 2 of this item and item Roman 2 of this paragraph. The combined award for both economic and non-economic damages may not exceed a total of $890,000, of which non-economic damages may not exceed $400,000.
No. No, no. Did she?
Senator Lee.
No.
Yes? No?
No.
No. Okay. Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Pass.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator Jackson.
No.
Chairman Smith.
No on the amendment.
Amendment fails.
All right. Let's keep rolling.
We conforming these two? Are we conforming the changes? We make changes on page 21. Are we conforming page 22 to the same changes? Okay, just make sure we don't have to redo all, those carried over both sections, okay.
So moving on to,
On page 21? Yeah.
so that would apply in a wrongful death action where there are 2 or more claimants or beneficiaries. And it would provide that an award for non-economic damages can't exceed 150% of that $890,000.
Saying there's caps, and then this is adding more, higher caps.
So that's for the combined award.
Not individual.
Right.
So you got 3 people got hit by a cruiser or something. They're just capping at 150% of the 890. So even if you had 10 people, it would still be capped.
Right. Regardless of the number of claimants or beneficiaries who share in the award, non-economic damages could not exceed 150% of that limit. Yeah, right.
So that should be viewed. I mean, that should be viewed as an extreme limitation in that sense. All right, Senator Bailey.
So I have my light on just for a little while, but when we're talking about the liability and we set the cap that we just set, I definitely think that some of you are clearly from different jurisdictions that have an ability to pay that is much different from some of the jurisdictions that the rest of us represent. And I'm just going to put this out there that if we're dealing with this cap, I mean, I see that cap as not a large monetary value for, places like Montgomery and Baltimore City, and Prince George's, but some of the areas of the rest of the state, I don't exactly know how to phrase this, but we should have a downward departure from this based on our wealth formula, so that it is the same impact to our jurisdictions as it is to yours. But I've got to say, when we look at 900,000 for Montgomery County versus 900,000 in a budget for the counties that I represent, significant different percentage of our wealth and our budget.
Not at the moment.
So going on, if you turn to page 28, we get back to police discipline.
So I'm going to do my best here, but I might need some assistance. I think that when we deal, I'd like to make a motion talking about dealing with the actual caps that we just set, that those be set based on the wealth formula of the largest 4 jurisdictions, and that the rest of the state's caps should be set on a downward departure based on the same formula for their jurisdictions. Second.
No, could you repeat that, Senator? I just wanted to make sure I understood.
So when we talked about the actual limits, where we set the liability limits, that I think that limit should be set for the 4 highest jurisdictions, wealthiest jurisdictions, when we talk about Montgomery, Baltimore, Baltimore City, and Prince George's. And I think the rest of the state should have a downward departure based on their wealth formula. So it is percentage driven, so that when somebody does something wrong, it should be the same impact to that jurisdiction. It should not, when we talk about $1 million to St. Mary's or Calvert County's budget that they would have to pay, that is a significant amount of money. When you talk about $1 million to one of these other jurisdictions, it's like the cost of doing business. What is it? It's not even a penalty. So that's a big deal when we look at. I mean, look at Garrett County. What $1 million does in, $899,000 does in Garrett County. That's significant. So I think when we talk about this, we should be talking about the impact that it has on each jurisdiction, and each jurisdiction should feel it the same way.
In any other case, are we holding counties accountable differently according to their size? If we take police reform out, I mean, any other sort of tort liability matters, are we making any concessions based on size?
This is the only time we are making a special section for policing too. Nowhere else in tort law do we do what we're doing right here. So I guess in response, everywhere else in tort law, every case is treated the same. Now policing is different. So I guess that's the retort for that.
But it's not, I mean, the caps are the same, right? We're holding.
The caps are different for police now than it is for everybody else.
Changing the caps, but I mean, the broader bill was applying it across the board. Again,
Yeah, not really. I mean, like they're just like we just said, like med mal is different than some of the stuff that like a constitutional violation, but like it's like a.
I'm not
it's not really
talking about
analogous
private.
because we're
I'm
not.
talking about public.
If you're at a hospital in Allegheny County, it's the same as your hospital in Montgomery County. I get it. So that's more, I think, analogous.
No, I'm talking about public jurisdictions.
No, I hear what you're saying, and I'm not aware of it.
Right. So I would speak against that. I don't think that we should, again, I said it before, I don't think that based on size, that we should hold a smaller county any less responsible than we do a larger county.
Why do we have a cap for the larger counties?
We have a cap across the board.
but the cap affects the larger counties much differently than it does the smaller counties.
I understand that.
Right, so it comes down to a fairness issue.
So you got a motion, you got a second. We'll roll it.
So what Senator Bailey's point is that when Montgomery County was only 50,000 people, they had a really small cap, and they got the benefit of that. And now Worcester County and Caroline County, they're still at that level. And Montgomery County has over 1 million people. So now Montgomery County is saying, well, wait a second, that's not a lot of money. We can spend lots of money around here, and we're a wealthy county. But these other counties are saying, wait a second, we're not wealthy. And it's just a continuing challenge we have in this body when our counties include everything from the richest counties in the entire country to counties that are right there in the lower half of the country. They're not wealthy counties at all. And then we try to discuss legislation, that's statewide legislation that says one size fits all. You're all loaded. You got lots of money. It's only $1 million. It's chicken feed. We put that in the new, that's what we spent on the AstroTurf in the ballpark last week in the local high school. So it's tough for us. It makes it a challenge for those smaller counties because their rates will go up. The rates that they have to pay through for their police insurance is going to go up, and then they're going to have to adjust. And the rates will say, how many police officers do you have? And that's how much your rates will be. If you have 5 police officers, it'll be this much. If you have 10, it'll be this much. And 20, and the municipalities will have to say, wow, we got to fire these 2 cops, because if we fire those 2, our insurance rates are going to drop substantially. And that's how they're going to start doing this stuff. So that's what we're doing. We're mixing in a bill that has not supposed to be about that. We're stuffing this in there, and it's going to come back because we're already hampering police law enforcement enough that it is.
This is clearly a fairness issue when we talk about this. And the one thing that was made clear to me the first day when I sat on the floor of the Senate was the fact that we were senators for the entire state of Maryland. We represent every single jurisdiction. We have to look at the people in the outlying areas the same way we look at the areas in the inside the Beltway. When we talk about this, when we talk about fairness, when we talk about money. And this is where the rubber hits the road when we discuss this. This is a fair, I'm not going to say it's well crafted. I think we could probably do a little better, but the fact is, the thing is, it affects other jurisdictions differently. And when we're talking about fairness in policing, well, the whole reason we're here is we want to do something that affects the whole state of Maryland the same way. And this doesn't affect the whole state of Maryland the same way. This affects the urban areas and the rural areas completely different, and we shouldn't do that.
All right, well, I guess I'll just, the inverse is also true for the victim. I mean, if the same grievance act happens in Montgomery County or, Wycomico, wherever, then you're going to get less money, less justice, less access, just because of where it happened. I mean, that's also a reality of what that would do. But
absolutely, I couldn't agree more with you about that, right? And that is why when we talk about these limits, the fact is that the jurisdictions should be responsible for their own policemen, and policewomen, and they should be saying, you know what, we're going to hold them to a standard. That's the whole reason the limits got elevated. The standard shouldn't be different if you're in a rural county versus urban county. It shouldn't be, but that's what we're doing.
Well, the reason why this is so controversial is we're talking about more than doubling the cap. If we left the cap the way it is, I don't think you'd have anybody being upset. But when you more than double the cap, the small counties and municipalities where one judgment could cause them to go bankrupt, literally. The town of Brunswick could go bankrupt if there's a single judgment, thanks to doubling the cap. That's the problem here.
The problem is what they'll actually do is just hand it over to resident troopers. So if you don't fix this and leave it like it is, like I said, they'll just get rid of their community policing. If the idea is to do police reform and get better policing out of this, potentially blowing up local police departments all throughout the state, I don't think gets you that. I think you're better off having, there's something to the old show, the Andy Griffith Show. Remember, there's this episode. I know I'm getting off path here, but like the state trooper comes in and he wants to get the gun out and go arrest the guy, and Andy's like, "I know that guy. I'll just go down and talk to him or whatever." But there's some actual truth to that. That these community policing and these small police forces are really good. They know the people, and so that's what they'll do. You make it too expensive for little towns throughout Western Maryland, Eastern Shore. There's like 100 of them. You make it too expensive. They're even in there. It's actually, this isn't just Western Maryland. Prince George's County has a ton of small municipalities. I don't know if they're all unified or what under one, but you make it too expensive, they'll just turn them over to state troopers and other people, and you lose community policing.
Well, I'll suggest an amendment, which would be a sort of a compromise. Instead of going to $860, or is it $890,000 from $400,000, take it from $400 to $550. That's a significant increase, far more than the rate of inflation over the past 5 years. And it would be much more tolerable for the small communities around the state.
All right. Yep, good.
If you're going to separate out the two, you could say counties 300,000 and less. You could either reduce the overall cap, which helps, or at least reduce it for counties that are 300,000 and less.
All right, well, here, let's do this.
Give them a smaller increase.
We got, we've got maybe three proposed amendments right now. So let's do Senator Bailey's amendment first. It has been offered and then seconded. So do you want to roll? Huh?
Yeah, I can just withdraw mine.
Okay.
And we can work with one of the others.
Okay, so then we go back to Senator, kind of the combination of Senator West and Huff. You have an amendment you want to?
I suggested changing it from $890,000 to $550,000.
Maybe more palpable. I would totally agree with going to 550. I would suggest if that amendment doesn't pass, we look at one that says for counties that are 300,000 and less, that they only increase to 550.
Okay.
So I guess just thing there, because I know that if the municipalities are a problem, you have those municipalities that are in Prince George's County or Montgomery County that wouldn't be included in that because you just went county level.
Well, I mean, they're less than 300,000.
So any jurisdiction under 300,000 or something like that. Okay, got it. Okay, so you want to do yours first?
Sure. So mine would be we change $890,000. Why do we have to have the municipalities the same as the state? Is it possible to have the counties and municipalities at 550 and leave the state at 890 and make it less of a change? Is there some problem with that, council? Could we do that?
I don't see any reason why you couldn't pick a different number.
All right, so to try to make the change, my proposed amendment less imposing, I would only suggest changing the $890,000 in the section of the bill that deals with the local jurisdictions from $890,000 to $550,000.
Vice Chair Waldstreicher.
No.
Senator Lee.
No.
Senator Castle.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Chairman Smith.
No.
The amendment fails.
All right, you got another amendment?
Yeah, I'll try
my last one. Yep. Yeah, that's it. Whatever, man.
I'm giving up. I would just say for put it at the 300,000 threshold, that they go up, they will increase by 100,000, and then everyone else above that goes to 890. So if you have a population of 300 or less,
So for jurisdiction,
yes,
300, so county, municipality, whatever it is.
this would be your small counties, municipalities.
Yeah. So it would stay steady state right now for those below, and for above, we go up. Seconded, the amendment's been seconded. Do you want to roll it?
Yes.
Okay.
Vice Chair Waldstreicher.
No.
Senator Lee.
No.
Senator Castle.
Yes.
Senator Huddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Chairman Smith.
Nope.
The
Okay.
amendment fails.
All right, keep rolling.
And so we already went over, there's the State Tort Claims Act, and then the rest of the bill provisions up until page 28 are struck, and then we're back at police discipline.
We're back where we started, whenever it was. Was it today? It seems like 3 weeks ago now. I would propose for conversation that this Police Accountability Board be stripped of its ability to receive complaints. There's nothing in here about what it does with the complaints. It just receives complaints. We don't know whether it's supposed to investigate complaints or pass them on to someone. No, I'm sorry, I'm on page 30, line 11. It says the Police Accountability Board, each county shall have a Police Accountability Board to 3, receive complaints. Again, there's nothing in this bill about what happens to them and who investigates them. So I would strip that language out, and I would leave as the only organization to receive the complaints the agency, which is on the following page, on page 31, and I would add a provision before we get to the next section that charges the agency with investigating any complaints. See, if you do that, I think you sort of tie things together, and it's like the chain of custody. This is what happens from where's the complaint filed, what happens to it, and then where does it go next?
I think that the vision for the PAB was to have, so in terms of receiving those complaints, I know they can't really take action on them. It's part of their supervisory and kind of oversight role to be in receipt and understand what's going on.
But I don't think it does take action on them.
No, they don't. They don't.
They don't. They just.
But part of their role is supervisory and kind of.
No, their role is to appoint civilian members to charging committees. So after the investigation, which is not provided for in this bill at the moment, after that, the charging committee takes over. That's under this scheme.
No, I know they don't play a role in the disciplinary process per se.
No.
But they have that oversight role. And so when they receive the complaints, they review the outcomes of the disciplinary matters considered by the charging committees. That's part of their that's part of their charter, is that oversight. So they need to have that information.
But at the moment, the complaints are filed both with the police accountability boards and with the agencies, which is weird. I mean, it's not designed by somebody who knows how to design a hierarchical system.
I see what you're saying, because it should be something like,
No, you don't.
it should be something that's passed up through
Yeah.
and not entry
The
point where they can't
complaints
take it.
ought to go to one place.
I hear what you're saying. Can you, Senator Carter, Senator
There's a
Cassidy?
really practical aspect of what he's saying, and that's that this Police Accountability Board meets quarterly. So you're not want people waiting 4 months to file it. It's not like they have this staff or their office. They're this sort of group of people that comes together quarterly and holds a meeting in the county council chambers or something like that, and they talk. You need a report that's filed. It's got to be of somebody who's there 24 hours, 7 days a week, who can give you a stamp and say, here, I've logged this in, I got your complaint, here's your copy, here's my copy, it was filed on June 3rd, we have time, now we start taking action from that date. And I don't know how this informal body is going to be able to function as such, and I would be concerned that complaints would be lost and not. And the other nice part about the police doing it is they're all in a larger jurisdiction. They're everywhere versus having to come into the middle of the. You'd have to come to one body and find them and file your complaint. So I think Senator West has a really good point on this.
So it appears to me that these police accountability boards, their function is sketchy. So to that extent, I agree with Senator West, but I would actually move in a different direction. I mean, if we're going to keep them, they should actually have some type of real authority. Right now, the way that they look, and some of you know that currently civilian review boards that exist are rendered relatively impotent because they don't have any real authority. They have statutory authority to exist, but then they don't have any real authority to make any substantial changes when it comes to police conduct or agency conduct. So right now, the way that they are listed in this bill, they're superfluous. They exist, they seem to have a purpose, but they don't really serve a purpose. And so I would actually suggest we should go in a different direction and solidify what their actual duties and authority is, as opposed, if they're going to be here, they ought to have some real authority, and they don't appear to have any right now. So I'm not even sure why they're receiving complaints if they don't have any power to make a decision on complaints. So maybe Jamie or someone can clear that up, but I also think that if they're going to exist, they ought to have a function aside from just, making us feel good, like creating civilian review boards has done, where they exist and they make us feel good because we have a board, but then we have a board that has zero authority to do anything. And that's what we're doing here. So,
Board and the charging commission, right? You want to combine those. I mean, that charging commission is on page 31. I don't disagree with what you're saying, Senator. It's just that it sounds like what you want to do is combine these two, because the County Administrative Charging Commission does have a lot of power, and I'm kind of with you. This other one is just sort of a stopgap. Why don't you just combine those, make them one, and be done with it? Because this other one does have investigative and charging powers, right?
Efficacy of having the two, and maybe there's someone that could clear it up for me, but I agree. We started out in some kind of effort to streamline a process, and it appears that we've added additional layers of sort of bureaucracy, but not with a real purpose.
You got it.
And so I do think that we should have a discussion, if we're going to have these boards, and figuring out how to empower them and streamline the authority.
All right. Any other discussion on this topic? Senator Jackson?
Yeah, I can tell you that that's refreshing to hear Senator Carter mention that. I think this section just is a reflection to me of somewhat of, what is it, 114 that we took out earlier. So I think there's some clarification that needs to be done if it's needed. We asked in our product to take this out. So.
All right. Well, we've got nothing before us now. Why don't we keep heading?
Didn't Senator West make a motion, right?
Go ahead, Senator West.
All right. This is nothing formal. It's just a discussion. So we totally get rid of the Police Accountability Board because if we take its right to receive complaints away from it, which we should, all that's left is appointing the civilian members to the other committees. That's all they do. So get rid of that and have the chief of police appoint the members of these various committees along the lines that we provided in our version of this bill a month and a half ago. Then you've taken away one of the levels of bureaucracy. Well, we already eliminated this independent investigatory agency at the state level, so now we can get rid of the Police Accountability Board in each county and just have the Administrative Charging Committee and the trial boards, which makes a whole lot more sense and cuts back on the bureaucracy.
No real authority, and I'm not understanding what the purpose is. They seem to be similar to civilian review boards, which are impotent. So perhaps you can shed some light on why the need for these, and if we're going to have them, might we be able to give them some actual, legitimate authority and function?
On the PABs, like is that what we're back on?
Yeah.
Again, I'll just say, I mean, that's that extra civilian layer of transparency and inspection. That's the stated charter. There's no, you're right, they don't have subpoena power, they don't have the ability to discipline,
They just appoint people?
They don't do anything.
and review.
Review what?
So they receive the complaints of police misconduct. They, on a quarterly basis, review the outcomes of the disciplinary matters considered by the charging committees. So that's that level of kind of interaction and oversight. They're a public body. All their meetings are open. All their records are subject to public inspection. That's their charter.
So if they do it, they don't like what's done, what do? Write a letter to the editor? They write a very stern letter.
I think they feel frustration because I think that people see some of the, some bad conduct or some atrocities or things that need to be changed. They see that because they can see that through the transparency of this board. But then at the end of the day, they see the board has no power. So once again, I feel like it results in people feeling frustrated that they don't have power. So my suggestion would be that we would tighten up and give them a function and some authority.
I'm not sure what.
Senator Casserly seemed to think we should consolidate them with the charging boards. They'd have some authority, but my only concern with that is that they're only there at the beginning. They don't have any, that would leave them without any impact at the end. The beginning of a misconduct complaint, but that's it.
So it's. So let me
To strike their authority to receive the complaints and just have all of them go through the agency?
Well, we should at least do that.
If we could address that motion.
But once we've taken away that, there's almost nothing left. These are a couple of citizens who are not paid. They're unpaid citizens. They're required to hold quarterly meetings. So a group of citizens comes together 4 times a year to review outcomes. That's it. Why in the world are we creating this new bureaucratic entity of unpaid people to sit there 4 times a year and review outcomes. It doesn't make any sense.
I don't have a problem with them existing. I do think Senator West has a good motion to put that back with the agency. I don't see any harm with the Police Accountability Board, but I would like to see a responsible bureaucratic move to strike their authority to receive the complaints.
So we're going to do a roll on this. Let's wait for the.
While we're waiting for him, can Jamie review we struck certain language this morning on page 31. Can you just review where we are now so we don't redo that?
I think we just got rid of anonymous complaints.
Okay, so we know we got back. Let's just real quick. Let's take that vote real quick, and then we'll come back. All right.
I mean, is there?
Motion, and then come back to this discussion right now.
Vice Chair Wallstraker.
No.
Vice Chair Wallstraker.
No.
Okay, sorry, I can't hear. Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No, and I'd like to go back to where we were with the Senate bill.
Well, then you should vote for this.
You should vote yes, dude.
Senator Bailey.
Yes, right?
He said no. Senator Bailey.
Yes.
Senator Carter.
My vote is no, but I'd like to continue the discussion about their authority. Thank you.
Senator Huff.
Yes. Hey, Michael.
Chairman Smith.
No.
Bill fails.
Senator West.
One of those people who voted no on this would care to tell us what this Police Accountability Board is expected to do with the complaints that it receives when it meets once a quarter.
How they're going to log them in and how they're going to be responsible.
Gus, which is the fact, Mr. Chair, that these boards, they say that they receive complaints and then they don't have any other process that they do. So they are really powerless, and I do think, because you know I am I'm a champion of civilian oversight, but the problem with civilian oversight is we create it and then we don't give it authority, and this just seems like doing more of what we've already done when we've allowed for civilian review boards. So I really do think if we're going to create it, they ought to have some authority or some real purpose.
Again, just say, look, before what we did was we made it optional, not mandatory. This is mandatory. And second, again, I think it plays a valuable role in that public oversight and exposure process. So you'll have an inspection and a review, and people that are able to communicate publicly about the state of affairs and things that are happening. So,
but Mr. Chair,
I understand there are no teeth and there's no subpoena power and there's no ability to discipline. I understand all that. Senator West.
If this board meets on the first day of each calendar quarter, January 2nd, April 1st, July 1st, and October 1st, and someone files a complaint on January 3rd with that board, assuming that there's someone there to receive the complaint, there's nothing in this statute that provides what happens to that complaint other than to sit around for 88 days until the board next meets.
So, but there, in contrast, there's nothing that says that they can't immediately refer it to the local agency to investigate. Is that correct?
So, and that's the thing that is, so the complaint, so this is a public process, that complaint would go, to both, right? So it would go to, it could go to both.
Both the state and local. Is
Say
right?
that again.
Wait, both, when you say both, what do you mean?
So it could go to the PAB,
Right?
or you could send it to the charging
The
committee.
the local police
To the local law
department.
enforcement, yeah.
Either one.
Okay, so there's nothing that precludes the local police department from acting or having to wait until the next meeting of the PAB, right?
They won't have the complaint.
Page 39, there is a time requirement. Lines 18 through 21, it says the process of, well, so this is the investigation, not necessarily the complaint. So this would be the process of review by the investigating unit through disposition of the administrative charging committee shall be completed within 1 year and 1 day. Oh, after the filing of a complaint by a citizen, so it is a 1 year from the complaint.
Just to be clear, though, so you could get a complaint, but then if that complaint then spurs an investigation, the timeline is different. So the investigation is a different kind of timeline. So just want to make sure that's clear. Can you get Senator West?
The bill contains no provision for an investigation. It was originally in the IAA part of the bill, which we have deleted. So there is currently no provision for an investigation, and specifically, there's nothing in this bill that gives the PAB any investigatory powers at all.
Now, we had this discussion earlier. Let me just, it's a little bit more than just implied. There's some language that,
Tell me where it is.
so on page 33, I think 14 through 16, is a review the findings of a law enforcement agency's investigation conducted and then forwarded in accordance with subsection D of this section. So
That's the law enforcement agency. That's not the PAB.
But that speaks to the who's conducting the investigation.
My point was, when the complaints are filed with the PAB, they do not have any powers to investigate under this bill.
That's absolutely true.
And there's nothing in this bill about what happens to the complaint. It just sits in limbo until the next meeting of the PAB, which could be 3 months later.
It does feel like there's like this build up and then a big drop off. I mean, this language here says that they then have, after they can appoint to the charging committees, that they then have the power to review those decisions. So if they're reviewing those decisions, should there not be an outcome for that? Like, they review the decisions and what? They review the decisions and report on data. They review the decisions and they can override a decision. I mean, there should be something that there exists to do other than just make people feel like there's something that's out there that really can't help them.
I would just want to stick to where Senator, I think that the point before us right now is whether we should, if I didn't miss something, is whether we should take the authority. Have we already voted on that? Not to take the authority away to them to receive the complaints? I guess maybe that's resolved perhaps. But so if that's resolved, maybe some of the people who supported that can explain to us. It seems like we're just voting based upon party alliances or something. We pointed out critical flaws in this process, and all we get is, no, we're not going to change it because Adrian says this is the law and that's the law. I'm trying to understand there's critical flaws here, i.e. they only sit every 4 months. They don't have a clerk. They don't staff stuff in. There's no requirement for them, like there would for the desk officer, to give copies and stamp it in. We have no control over complaints that are coming in that are really critical and impact people's lives. And then all they're going is serving as a clerk's office, so they're going to receive these things just because somebody, for some inexplicable reason, we want to say, well, you can give it to them or to the agency. and we point out these critical flaws, and all we get is no changes to this. Because somebody is, I don't understand. Do you have other amendments that are going to build this one up? Because, maybe in Montgomery County, you're going to have a full-time police accountability board with a nice big building with full-time staff. But in every other county out there, pretty much, it's going to be, they're going to come and meet in the county council chambers once every 4 months. They have no staff. They're on their own. They're not paid. And they're going to have a big inbox. And they'll get there and they'll check their inbox. And it's got a stack of complaints in there. And they'll say, oh, look at these. Let's look at this stuff. We're supposed to take these, open them up, and then give them to somebody else. And we're all saying, well, that's a great system. Really? Is that? I'm sorry. I don't understand the votes that we're doing. It just seems like we're just voting to vote and not to effectuate any kind of rational public policy.
So, there was section 3102 that talked about this independent investigative agency. So maybe if we're looking to give them some authority, I'd like to move that we give them investigatory powers.
Thank you, Mr. Chair. So if we give them investigatory powers, they're going to have a staff of trained investigators. So we have a fiscal note now in every county in the state, because this is divided county by county. So we have this accountability board, which only meets every 4 months, but it's going to have a staff of people who I guess will do whatever needs to be done in between, in their absence. This sounds like the ultimate Rube Goldberg machine that hasn't been thought out, that we're trying to patch together because we have an injunction that we have to come up with this bill by the end of the day. This is not the way to run a railroad.
I mean, look, you've already got this quasi-investigation is the charging committee, because they're the ones that, if you look a few pages ahead in the bill, they're the ones that review everything, can ask for additional information, have the police do additional investigations, and come back. So there's no reason to write new powers in the Police Accountability Board, because the powers you're discussing are with the Charging Commission, and there's no reason to do that. I mean, I don't have a problem with the structure of the Police Accountability Board. My only problem is that we're going to screw up complaints, and as a lawyer, and we're used to filing things in a clerk's office, and you get things stamped, and we know when they're in, and now we've just lost all accountability for no reason other than we're saying, no, we want to be able to do this, and I don't know who's on first, anyway.
This for 3 hours? Huh? We'd have this for 3.5 hours, take a dinner break, come back. We'll take a dinner break and come back. You want to press the roll it or whatever? You want to... What is the amendment? What is it? So Sidnor made an amendment. Senator Carter.
The county accountability boards would have investigative authority. Did I get that right, Senator?
We're going to pause right there.
Okay.
We'll roll it. That'll be the first thing we roll when we come back.
I mean, we made changes and we adopted some changes. I wouldn't want to plowed ground, but I can't remember what we did. Yeah, we're right there. I just want to say that's, I would hope we can, okay. Okay.
45-minute break, 6:45. Come back 6:45.